Good morning. I'd like to welcome everyone to the August 9th, 2016 meeting of the City of Columbia Board of Zoning Appeals. I am Chuck Sally and I serve as chair of the board. At this time, I'd like to introduce the other members of the board. To my far left is Reggie McKnight. To my immediate left is Pat Hubbard. To my right is Tyler Gregg. And to my far right is Calhoun McMeekin. This time, I'd also like to introduce the staff that will assist the board during this meeting. We have Brian Cook, the zoning administrator, Andrew Livingood, the deputy zoning administrator. Also assisting will be Andrea Wolf, the senior secretary for planning and development services. The board is charged with applications for special exceptions, variances, and administrative appeals. All testimony is recorded for the record, and everyone wishing to speak will need to be sworn and must come to the podium to speak. No testimony can be taken from the floor. When you come to the podium, please state your name and please speak clearly into the microphone because the meeting is being recorded. For those of you who plan to speak, you must be sworn. So if you're here as an applicant or if you plan to speak in any case, please stand at this time and raise your right hand. Do you affirm or attest that the testimony you will give today is the truth and nothing but the truth? Thank you. Now I'd like to turn it over to Brian Cook.
Thank you, Mr. Chairman. Good morning, everyone. Just a few housekeeping items. Just a reminder to, if you have a cell phone or other device, please put it on vibrate. The consent agenda, the Board of Zoning Appeals uses the consent agenda to approve non-controversial or routine matters by single motion and vote. If a member of the board or general public wants to discuss an item on the consent agenda at the beginning of the meeting, that item is removed from the consent agenda and considered during the meeting. The board then approves the remaining consent agenda. If an item is removed from the consent agenda, that item will be heard after old business on the regular agenda. So after I read the consent agenda, if anyone in the audience or anyone on the board would like an item removed from the consent agenda, please raise your hand or otherwise get the attention of the chairperson. Meeting format is as follows. The applicant will get allotted a time of 10 minutes for their presentation. This time should include, but is not limited to, an overview of the project, case history, or any pertinent meetings held regarding the request. This time also includes all persons presenting information on behalf of the applicant, such as attorneys, engineers, and architects. This time limit does not include questions asked by Board of Zoning Appeals or staff regarding the request. Zoning staff may take a 10-minute presentation. Any member of the general public may address the Board of Zoning Appeals in intervals for 3 minutes or 5 minutes if a spokesman for an established body or for a group of 3 or more. The applicant will then have 5 minutes for rebuttal. A pretty large agenda today. I think a lot of people probably want to speak, so we're going to try to keep to that meeting format for applicants and members of the general public that would like to address the board. We'll start with the consent agenda. The approval of July 12, 2016 minutes is item number 1. Item number 2 is 16-039 variance at 2400 Divine Street, tax map 113120601, variance to the parking requirements for a restaurant. Mr. Chairman, anyone in the audience or anyone on the board like either item removed from the consent agenda?
I would like to address a minor point, but to me an important point about item number 2, please.
Yes, sir. Proceed.
Is the applicant here? How do you want to do the minutes separately and then go to number 2?
Yeah, sure.
I move to approve the minutes.
Second. We have a movement and a second. Is there all in favor say aye? Aye. Minutes are approved.
Can we go to case number 2 and have the applicant?
That's case 16039 variance at 2400 Divine Street. Is the applicant present, please?
Yes. If you please approach the podium. We just have a question. I think Pat has a question or a statement he wants to make just to affirm something in the application.
Familiar with the property. I live not far away. I'm very supportive of what you want to do, so please relax. It states in the materials that valet parking will be provided. I'm not even sure you would need that today because there's plenty of on-street parking there, but a few years down the road, that might not be the case. So I wondered if you mind having the provision of valet parking be a condition of the granting of the parking variance, which means that you would have to provide it. Yes. You do not mind? You're willing to accept that condition?
The new restaurant owner is aware of that.
Pardon?
The new restaurant owner is aware that
Okay.
there would be that he would have.
So that will be, you don't mind being a condition of the parking variance? Thank you.
Oh, I'm sorry. I didn't state my name. I'm Diane Light.
Thank you, Diane.
Thank you. Now you ask if there's anybody else.
Is there anyone else that would like to say anything before we vote? Okay, I'd like to entertain a motion then.
I move to approve the request for variance, subject to the condition that valet parking will be provided as stated in the materials. So it's a condition of the granting of the variance.
Second.
All in favor?
Aye.
Aye. Motion passes.
Thank you, Mr. Chairman. Move to the regular agenda under old business. The next two cases are tied together, and I believe Attorney Mr. Ward would like to address the board on case 16-024 variance and 16-25 variance. So it's my understanding that you would like to request a deferral until next month's meeting, but he is present and can speak for that.
Good morning, Mr. Chairman and members of the planning board. I would like to request a deferral. This will be the third one, but it's for a good cause. I couldn't be here the last time because I had a court hearing, and this time there's a purchaser who has agreed to do what the city has asked, but their due diligence does not run out until the middle of this month, and all indications are they're going to buy it. So I think if you'll give me one more deferral, this will go off and not need to be heard, but if it does need to be heard, then I'd be ready the next month.
Mr. Ward, would you please state your name?
I would. Toby Ward. I'd be glad to answer any questions that anyone might have.
I'm familiar with the case. I mean, it sounds like a reasonable request to me. I don't know if anybody would like to have any questions or a motion. We'll entertain a motion if someone would like to make one.
A part of me always likes to defer because it's one less thing, but I can't help but wonder, when will we get to this?
Next month.
No, I mean, were we really going to get,
Well,
what I want to say is at some point, I would find a problem with just continuing to defer.
yes, sir. Well, last time I had district court, which takes priority over this. So
But my understanding is there may not even be a
that's right.
next time.
I
In other
fully
words, if
expect-
they get the buyer to agree to all of the conditions they want.
If you can work it out, that would be good too.
Yes,
Thank
well, it's actually already worked out. We just got to get the buyer to buy, and their due diligence runs out the middle of this month. All indications are that they're going to move forward with the purchase, in which case staff has reached an agreement with the prospective purchaser to install the improvements required.
So they will comply with the requirements?
Yes, sir. Yes, sir.
Thank you.
You're welcome.
In that case, is there a motion?
Make a motion to defer until our next hearing.
Second.
All in favor, say aye.
Aye.
Opposed? Cashes. At this time, I would like to make an adjustment to the schedule. I know that about a month ago, the Mercy Group had a large number of consultants and individuals here all day long, and we had a very long day, and they were at the end of the agenda, and we actually were not able to vote on it because we had board members that had to leave, and they sat here all day and were not even able to vote on their application. And I just feel that as chairman of the board, I feel like it's important that that situation be addressed. I will be recusing myself from this, but I would like to get at least a vote from the board that we, a motion, I will make a motion that we move them to the front of the new business agenda, and I'll make that motion.
Second.
All in favor?
Aye.
Opposed? That carries. So at this time, I would like to turn the chairmanship over to Pat Hubbard, and I'll be removing myself from chair.
Can someone tell me, is my microphone on? Okay, yeah, I want to join Mr. Sally's remarks about what happened last time. I want to apologize on behalf of the board to the applicant and to the members of the public who came, waited patiently, and at the end of the day, we were not able to address it. And that, therefore, as Mr. Sally indicated, we're trying to at least fix that up by doing it now. I also want to stress that we've heard you, we've listened to you as to this application and as to a prior application. And so I want to try to enforce time limits to some extent. For example, if there's someone who wants to give the neighborhood point of view, I would appreciate there be a spokesperson. We had some repetition last time, people saying the same kinds of things, and I would appreciate, again, that we have a spokesperson and we'll try to enforce time limits to make that work. Similarly, the applicant had a lot of supporters here. If there's someone other than the applicant who wants to voice support, that again, I would want that to be a spokesperson. We've had a lot of testimony in prior hearings about the good works of Mercy, and we don't need to listen to all that again, I don't think, today. Similarly, I think we understand the problems of the neighborhood in dealing with having institutions placed in the neighborhood rather than residential uses. So I think we should start with the applicant, please.
Go ahead and just call the case real quick. It's 16-038, special exception at 1813 Washington Street, tax map 11406-0110. The application for a special exception is to allow the construction and establishment of a residential care facility on the property, which is currently being utilized as a parking lot. According to the applicant, the proposed facility is a housing program for unaccompanied youth aged 17 to 24 years old with 8 to 12 residents in the facility and would be staffed by professional social workers or counselors 24 hours a day. And of course, the applicants are here and answer any questions.
Hi, I'm Julianne Avon, and I'm the President and Executive Director of Mercy. We are a CARV-accredited behavioral health care provider. That's an international accreditation. We have the highest 3-year term that's available. We've been in existence since 1960. We provide supportive housing to over 300 individuals and families in the Midlands, over 200 of whom were homeless or chronically homeless upon entry in developing housing for over 20 years. We own 4 apartment communities and 2 group homes. We're committed to the Columbia community. In partnership with United Way of the Midlands and the Nord Family Foundation, we're seeking to develop a supportive housing program for young men aged 17 to 24. We're looking at young men who are aging out of the foster care system, young men who are homeless and unaccompanied attending schools referred to us by the school districts, and males who are above the age to stay in the limited family shelters with their mothers. The program will intervene early and Okay. The program will intervene early and will prevent these young men from becoming chronically homeless and reduce the stressors that lead to serious mental illness. Before looking for the property, we met with the zoning staff to determine what type of property would be most in line for our planned use. Staff suggested C1 with an application for exception. The term residential care facility is for zoning purposes, and it's not the same as those for licensed treatment facilities. This will not be a treatment facility. We followed the process outlined by the city. Some of y'all probably recall we received approval for a property on Hampton Street back in November. That project turned out too costly, so we've moved some of our off-site parking for another program and got approval for that at the May meeting here of the Board of Zoning Appeals. So what we're proposing is to put the home on the property at 1813 Washington that Mercy owns. It'll be a good fit in the neighborhood, will blend well, there'll be one less parking lot. There's been a lot of misinformation kind of disseminated. I want you to know that Mercy will not be housing sex offenders, drug addicts, or criminals. We're going to be housing unaccompanied youth and young men, providing them with the assistance they need to develop skills, to live independently, and to be self-sufficient. When they're in our housing program, there'll be rules. Those will include curfews, rules on visitors, no alcohol or drugs, no loitering. Smoking will have to be in a designated smoking area and only allowed for those 18 or older. I've got 3 pages of those guidelines, which the guys will live by. So with that said, I'd like to turn it over to Michael Wenzinger, who is the architect working with us, and he'll present on the criteria.
All right, well, just jumping into the criteria, looking at criteria number 1, which addresses vehicular traffic on the site. There's currently a single curb cut leading into the property from Washington Street. The proposed project will maintain this condition and will not have an adverse impact on vehicular traffic or vehicular and pedestrian safety. Traffic to and from this facility will be minimal.
Excuse me a minute. I just want to, in terms of traffic and safety and parking, you have 2 site plans, or called conceptual site plans, option A and option B. Which one are you?
The only difference between the site plans, we haven't gotten into the design of the actual building yet, so we did just want to show the feasibility of the parking being situated on the site.
I guess, well, anticipating item 3, aesthetics, I think it does matter whether you park them in front, park them in back, how you screen, and that sort of thing.
Yeah, and we can, either one's feasible. With this project, obviously cost is a concern, so due to the grading on the site, in theory, it should be more cost-effective to place the building further back. That said, we did talk with staff, and based on, I think it was an average of like aggregate setback of 7.5 feet, so we could go closer to the street. We think that could help, to your point, aesthetically, and help redefining the block and help creating that street edge.
It's more looking like...
That would be our preference, but it is something that to some degree is cost contingent. That said, if that were to be made, a conditional piece of the approval, there's a lot of ways we can manage costs. So, I'm sure we could address that, in other ways than the site layout.
Thank you.
You're welcome. In referencing both of those conceptual site layouts, each of those show that the required 3 parking spaces are there's adequate room for that on the site, as well as with the building. All right, addressing criteria 2, the proposed special exception will not have a substantial adverse impact on adjoining properties in terms of environmental factors such as noise, lights, glare, vibration, fumes, odors, obstructions of air or light, and litter. The proposed special exception will offer counseling services to unaccompanied youth ages 17 to 24. Julianne clearly outlined the the guidelines, and this is this has been compared to a facility like Transitions, and obviously this is significantly different. It's not 200 people being served there. Loitering won't be happening outside. It's a much more controlled, managed, much smaller organization and program. These services will be unobtrusive in nature and occur within typical business hours, not causing any significant noise, light, litter, or other adverse impacts listed above. And in your packet too, we do have reference just images of other Mercy properties, and you can just kind of plainly see, I think, the level to which they're cared for. Going to criteria 3. The proposed special exception will not have a substantial adverse impact on the aesthetic character of the area, to include a review of the orientation and spacing of buildings. So we just address that to some degree with the site. The proposed project will improve the aesthetic character of the area. The site on Washington Street is currently a parking lot. The proposed project will help to redefine the block by creating a stronger street edge. The new building will be consistent with the aesthetic character and scale of the surrounding context, maintaining a historic residential style. The building will be 2 levels and approximately 2,500 square feet, consistent with the scale of the neighborhood. We've also provided additional just aesthetic justification information, case study images.
Can we, in terms of aesthetics, what about, is there going to be any screening of that parking area from adjacent properties?
There certainly can be. I think we'll better understand that once we really get into the site layout. But again, that we'd certainly welcome that as a contingent piece of our application.
Question to the staff: are there rules about screening for the parking in a residential area like this?
There is a requirement if the parking lot is closer to the street that it be screened by what we call a street protective yard. Otherwise, the required screening depends on what the adjacent use is. So if, for example, there was a residence next door, then there would be screening required. I'm not certain what the requirements would be in this particular case, however. I don't think
So to the
there's
extent
an item that would require
to the extent the property abuts a residence, the parking would have to be screened. If it doesn't abut any residences, there's no screening.
Well, actually, or the development in general would need to be screened. But I do not believe there is an adjacent residence in this case.
Okay.
So, but the street protective yard would still be required, which is generally a low row of shrubs to kind of break up the.
Well, I'm just one member of the board, but I think it looks more like a house if the parking's in the back than in the front.
Sure.
So, I mean,
And I think just speaking architecturally, I think regardless of what the criteria are, I think parking is something we'd want to screen. I think we are looking to positively improve the neighborhood with a aesthetically attractive development. So the last thing we want to do is just replace a parking lot with a parking lot and a building, right? We want it to feel residential. And just a point of clarification too, there certainly are residents that live in this area, and we respect that, and want to be a good neighbor. But that said, it is C1 commercial. When we say placing an institution in a residential area, institutions are permitted outright in this district.
that's partly why I wanted to find out about what the rules are.
Okay. Criteria 4, the proposed special exception will not have a substantial adverse impact on public safety or create nuisance conditions detrimental to the public interest or conditions likely to result in increased law enforcement response. The proposed project will maintain a professional staff person on site at all times. The staff person will enforce various program rules and regulations to minimize the potential for nuisance conditions. The staff person will primarily monitor clients, but their 24-hour presence on site will contribute to improved public safety of the immediate property and surrounding area, limiting the potential for nuisance conditions beyond our immediate project. As a residential type use, the proposed project will provide, quote, eyes on the street after the adjacent businesses leave for the evening. There are currently no residential type uses on this side of the block. All right, criteria 5. This, has been a bigger one throughout these discussions, but we did want to kind of break this down into 2 pieces just to really analyze the question and look at what's being asked, and that's how we've addressed it. The establishment of the proposed special exception does not create a concentration or proliferation of the same or similar types of special exception use. So just addressing the first criteria, no, we don't believe that it does create a concentration of the same or similar type. Christ Central are much larger facilities than us. So when you really look at the character of our, it is a residential care. Many of those other institutions are not, or they're permitted outright. You're talking about 260 beds as opposed to 8 to 12 beds. So they have just a much different character to them, and we do view those differently. Now that said, if they were to be viewed as the same, we did create this density map just to kind of look at these different properties that have been mentioned. If you look at it, you can see on average that the listed properties are about 1.6 miles away from our facility. I think if you look at the size of downtown and look at what 1.6 miles covers, I think when we speak of a density, it's fairly subjective, but again, we would reiterate that we don't feel that causes the density. I mean, you're effectively looking at Gervais to Elmwood, which is almost half of downtown in that direction. So just looking at the second piece, though, which I think really is important, which concentration may be detrimental to the development or redevelopment of the area in which the special exception use is proposed to be developed. And we think it's actually doing the opposite. I think when you look at the neighborhood, historically or not recently, in recent history, I suppose, there hasn't been a lot of activity. Has their offices located in this neighborhood now. That's a 20,000 square foot, $5 million investment into the neighborhood. Our project would also be another investment into the neighborhood, and these investments, these quote-unquote other facilities, to that effect. I think that that pretty clearly addresses it. Like we said, there are two closer ones, with Fatherhood Coalition and Columbia Urban League. But again, no one's staying there overnight. Those are really no different than any other business in the services that they offer. I wouldn't consider them the same or similar. I think it's great that our client and United Way and other people are see it's happening, and I think that can be a catalyst for development. It's contagious. People see that and they get excited about the potential for the community as well. So criteria 6, the proposed special exception is consistent with the character and intent of the underlying district as indicated in the zoning district description, with any applicable zoning overlay district goals and requirements. The proposed project does not have an overlay district, and the underlying district is C1. C1 allows for offices, institutions, and certain types of residential uses in areas whose characteristic is neither general commercial nor exclusively residential in nature. This area is not exclusively residential or commercial, and the proposed use is a hybrid between office, institution, and residential, which is consistent with the intent of the underlying district. And I think this one's very clear. And I think it's these same reasons that when we met with staff that they recommended that we look at developing the project in a C1 district. Yeah. Criteria 7. The proposed project is appropriate for its location and is compatible with the permitted uses adjacent to and in the vicinity of the project. As stated under criteria 6, the proposed use is compatible with the description of C1. This side of the block does not currently have a residential type use, so the addition of this project will provide added diversity to the neighborhood. And Fatherhood Coalition and Columbian Urban League are both our neighbors who are here to speak in support of the project. Lastly, the proposed special exception will not adversely affect the public interest. The proposed project will benefit the public interest at both a micro and macro level. At a micro level, the proposed project will help to redefine the block. It will improve the aesthetic character of the block. It will not contribute to nuisance conditions and will provide added diversity to the block, resulting in eyes on the street and improved public safety. These items will benefit the public interest of the immediate context. At a macro level, the proposed project will address a real problem in Columbia in a new way. Addressing the potential for homelessness before it happens will have a substantial impact on homelessness in Columbia and will set an example for a proactive approach rather than purely reactive. This will benefit the public interest at a macro level. Lastly, Mercy will be serving individuals from all over Columbia, which benefits the public interest in the immediate context and the city as a whole. Thank you.
Does anyone have questions? Thank you. Is there anyone else here to speak on behalf of the application in support of it? I stress again the point, I want too much repetition, so.
Good morning, members of the board. My name is Mac Bennett. I'm the CEO of United Way of the Midlands. Mike made reference to our recent move to this neighborhood. United Way has made one of the more significant investments in this neighborhood in the last several years. We moved this weekend from our current location on Main Street to 1818 Blanding Street, which is about 2.5 blocks from the proposed site. So we've made a significant investment in this neighborhood. We purchased a building property that had been vacant for over 8 years and redeveloped that property. Second point I'd like to make with you is that we have been a long-term funder of the Mental Illness Recovery Center. We found them to be an excellent partner in providing much-needed services in our community. I have personally visited many of their residents and find them to be well-kept, well-maintained, and an asset to the neighborhoods that they reside in. Finally, we know that youth in transition is a growing population in our community. Department of Education's research shows that in Richland County alone, there are over 200 youth that would qualify for a facility like this. Doing nothing is going to further exacerbate this problem. This is an appropriate space that is located close to educational facilities, faith-based facilities, and other providers. So we are in support of the proposed applicant. Thank you.
Are there any questions? Thank you.
Good morning. I'm J.T. McLaughlin, president of the Columbia Urban League. The Columbia Urban League has been located in that geographical footprint for about 30 years. We serve over 500 children in care, children in foster care. We're really concerned about the kids who age out of the system, and normally when they age out of the system, many of them become homeless, unemployed, do not have the kind of support system. We think this facility will complement what we're doing and will provide opportunity to help these young people become productive members of society. Quite often, those kids we work with, they come out of traumatic situations. They have some of the similar symptoms that military veterans have, PTSD, and a lot of times you don't have an intervention early enough to be able to help them to be able to maintain the type of quality of life they need. So this is an intervention program that's going to be very complementary to what we do at the Columbia Urban League in serving children in foster care.
Any questions?
You haven't answered any questions.
I just want to make sure. Apparently not. Thank you very much.
Okay.
Good morning. I'm Angela McDuffie. I'm the executive director of the Midlands Fatherhood Coalition, and we're looking forward to partnering with Mercy. We provide wraparound services for our young men, in particular fathers, but one of the biggest component we have is economic stability, which provides employability skills and soft skills that these individuals would need to become productive.
No questions? Thank you.
Good morning, I'm Stacy Atkinson, and I'm a youth advocate. Be still, hear them whisper, I want to be a neighbor. I want to be a good neighbor. And most importantly, I want to learn how to be a good neighbor. 17 to 24-year-olds that I have been working with want you to know that it is time to change the conversation. And today they have asked us to do just that. The young people that we were working with just yesterday in transition that are 18 to 24-year-olds, Alice Curtin from the United Way and myself were there, and they wanted to stand tall. They wanted to come here and begin to share with you that the story is different The conversation has changed. They wanted you to know what we learned in an icebreaker last week. They wanted you to know that they are emerging leaders, and this is how they describe themselves in the icebreaker. I am outspoken. I am determined. I am outgoing. I'm quiet. I'm loving. I'm goofy. I'm a little wild, and I am kind. I am Stacy Atkinson, and I have worked with the Department of Juvenile Justice over 27 years behind the fence, and we began building communities behind the fence and beyond. And one of the things that we have discovered that our kids' goals are the same as mine now that I'm retiring, or whether or not I'm a mom, or whether or not I am someone who is transitioning out of the military. They have some of the same hopes and dreams that we do. They want to have a place to belong. They want a community. They want someone to know their name. Over the last year, I have been working with a host of community partners, whether it's the United Way or the University of South Carolina in the School of Social Work, or psychology, or Samaritan's Well in Lexington. I have traveled to the far corners to Nashville, Tennessee, and Atlanta, wanting to learn about best practices. Because after spending 30 years in the field, I want to know why my kids are falling through the gap. Because whether they come from middle-class America or they come from urban Columbia, they need our help and they need a place to belong. And you will find in the last year, our kids are standing tall and they're asking, can I go to camp like other children as foster care? And Katrina Kids has stand tall with foster care kids throughout the state and said, we can. You will find that the young people have said, we want to help tell the story that when young people are in crisis, that we have a resource directory that has been built by kids for kids. So when you bring it all down, our kids want to be good neighbors like me and like you. But they must learn how, and they must have a place to begin to learn that. And together, with your help, those kids can learn those skills to actually finance their own future, live in a home, and a place to belong. Thank you.
Is there anyone else to speak in support of the application? Please do not be repetitive.
My name is Dean Slade, and I own an apartment at Barnwell Colony, which is student housing, and I would like to stand in support of this project and would like really for you to see this as the addition of student housing in a community where there is already student housing with an on-site manager, just like you would have with any other, that this is a great opportunity for low-income students to be able to access housing and have access to facilities. And in fact, the USC bus system operates from right across the street, so there's access to good transportation as well. So I just like to think it'd be a good addition to the community, and that student housing is already a part of that area. Thank you.
Thank you. Anyone else in support? Is there anyone in opposition who would like to speak?
My name is Hemphill Pride, and I've practiced law in this community for 54 years. And my office is 1401 Gregg Street, and buttresses the request for the exception in this matter. I'm here to oppose it. I've occupied 1401 Gregg Street for a period of 35 years, and I've seen the community slowly change. First came the parole board, which is at the next block of Gregg Street. Right next to me, in the house to my left, right next to me, is a center for abused women. Up the street is another social facility. Around directly behind me is the Urban League, and I think it's important to point out, as Mr. McLawhorn said, during the summer they service some 500 kids. Enough is enough. This community has taken on as much as it can from social agencies. I commend the mental health people who want to provide for these young people, but the purpose is great, but the place is not great. And I would oppose this and ask you not to grant this exception in this community. I want you to spread it around. Don't put it all in this community. This is a business community. Right across the street from me on Gregg Street is Mr. Screen, who is a lawyer. I know he's been there probably over 30 years and has practiced law for over 40 years. Categorically across the street from me is Dr. Rutherford. He's been there for over 40 years. This is primarily a business community. It's not, I don't think that there are about 3 residential houses in this area. And to bring in another social agency is just requesting too much. Thank you very much. If you have any questions, I'll be glad to address them.
Thank you very much.
Thank you.
I'm Jerry M. Screen. I own the property at 1337 Gregg Street. My primary concern is that less than 1/8 of a mile away from my office is the Richland County Probation Office, which services thousands of young people daily. The foot traffic in that area is awesome. They're across the yard, they're peeping in cars all day long, 5 days a week. Parking is almost non-existent. When they go down to probation to report, they're all the way back from the probation office on both sides, all the way back up the street on Gregg. This usage, proposed usage of this property will be burdensome vehicular traffic, foot traffic, overall makes it a burdensome project for this neighborhood. As noble as it is, I think that outweighs necessity for placing it in that particular area. There are other social areas. We are congested as it is up there. There's a funeral home right at my back door. There's a church there. When they have services and funerals, you can't get out. My clients can't get in. This is not the place for that facility. I urge you not to allow this exception.
Good morning. My name is Calvernetta Williams, and we are the undertakers there at A.P. Williams Funeral Home. And since we've been there for 100 years, our building, I think I have the most history for that area. We've been in business since 1936, but the place itself has been there for over 100 years. My father-in-law, A.P. Williams, is the reason why that funeral home is put on the National Register of Historic Places. And we do contribute to the United Way financially. And we're in support of the Urban League. That's a part of us, part of our history too. As a person, husband is at the funeral home right now, preparing himself for a family. You might have heard of the big pileup on I-20. We have one of those cases. And that family will be coming in. I'm here because we oppose this also. We were not included on the initial hearing. I learned about this on Wednesday, got a copy of what was going on because we were not questioned, and then I went from canvas from neighbor to neighbor and asked my neighbors had they heard of this. You do not see Bishop Williams because they have something going on today.
And I wanted to first clear up a misunderstanding that I heard, I believe Miss Avens said. She said it was a misconception going around that there would be housing, let me see, how did she say it, sex offenders. We don't have that misunderstanding. We never said that for those boys that are 17 to 24 years old. Because I teach, and I've taught for 44 years physics at the high schools in Richland School District 1. So I'm fully aware of the problems, the homelessness, because we've had to take those things in consideration also. But I'm here today to talk about basically what we can and cannot do. We're in support of the concept. We saw 2 signs. We were not unaware of what was going on across the street. We saw a sign, the first sign about a month ago that had on it, nursing care. So we talked to a couple of neighbors who I had seen, the property owners, and I said, how in the world are they going to put a nursing care facility here? It doesn't even make sense. Then the sign went down, and then it came back up, the zoning sign. And when the sign came back up, it had on it, and I took pictures of it, residential nursing care. And I felt that was deception right there. But when I got this big page, all of these pages.
I'm sorry. I do have to enforce time limits.
Okay, well, I'll get to it. We are opposing this because on our corner, we already, Ms. Taylor and Pam have houses, and they already house the parole board. We've seen the history of that street. We've tried to bring the integrity of the street up. And we do have sex offenders in some housing in some of the places on our street right now. And we've tried our best to work with them. The parole board also comes in because those are some of the clientels that are there. We're there 24 hours and 7 days. We have families that come in, and grieving families are very visual. And they see those kinds of things. And for the safety of our community, we would appreciate not having this in front of our doorstep when we're trying to serve the public. And we are a part of the city. Different ones come over since we are a historical district, and they are part of what the cities what they're advocating and things of that sort. But basically, that's what we are. Thank you.
Thank you. Is there anyone else to speak in opposition?
Good morning. My name is Josh A. English, and I stay at 1800 Washington Street. And we have a lot of homeless, and we have a lot of panhandling, sex offenders, parole board, sleeping and walking all through the parking lots, all around the house, throwing trash all in the areas, sleeping on Miss A.P. Wham porch. I have to call and tell her somebody on her porch sleeping. They're all around the house sleeping and peeing all around the house and begging for food, begging for money, begging for everything, drugging, everything they can do. And I will oppose with not having that in the area because I live there and I don't want to live in an area that I have to be afraid to sit up and lock up in the house all day long and all night. Have a blessed day.
Thank you. Is there anyone else who would like to speak in opposition?
My name is Betty Taylor, and I own the building at 1800 Washington Street. And I'm not going to make this long because I say ditto to everything that's already been said. But there is that parole board down the street on Gregg Street. And we have people coming in from getting off the bus off Sumter Street, walking through the area, and it's just different kinds of people. So if these people are not going to stay inside of the building all the time, then I'm afraid that they're going to pick up some of the habits that a lot of the other young folks around there have. We have a lot of stray people coming through, and like she said, we have a lot of stray people, a lot of people putting paper, trash in the neighborhood. And I oppose, too, for having that facility in that area. The concept and the idea of what they want to do is good, but I think it would be better if they could find another area to build in. I worked for social services. I retired from DSS. I worked there 33 years, and I worked over here at Health and Human Services. So I know about the foster children, and my grandparents were foster parents. My mother was a foster parent. And I know it's easy for those children to be persuaded by other children. And so, like I said, we have a lot of stray young people walking through the neighborhood different hours of the night. My husband also watched one of the stray guys break into one of the cars in the neighborhood. So I'm not going to be long. I'm just going to thank you.
Thank you.
My name is Joy Grimsley, and I work for Martin Psychiatric on the corner of Richland and Marion Street. First of all, I have a lot of empathy for those young men who are at risk, and I understand their need, as I've worked in forensic psychiatry for 40 years, and also am still doing that, and we do take care of the sex offenders in this county and many others who come to our facility for treatment. We are very careful that they come for a specific time and that they leave the area immediately because they are not supposed to be there. I don't live downtown. I don't live where these people live who would be at risk. I know these young men would be at risk even in that area for, like they say, learning things from those that are around them. I am in agreement with the need for this kind of facility for young men at that age because they do need positive reinforcement. And it would be wonderful if every lofty idea that comes up for all of these people who would like to do good things, if that actually worked out. In real life, it seldom does. I have had my own trouble with my own grandchildren who I worked with for many years to get them through these processes, and they all need one good mentor. I don't know whether they would have that, whether these young men would have men who would be there to take care of them and to mentor them and to bring them through this process to a better solution in life, which would take a lot of time. I understand the people that are in business in this area and how difficult this makes it for them because we do have an abundance of this kind of thing in the downtown and the area that we work in. Because I'm accosted regularly by people on the street who are coming from one place or another for money. Some are very obviously mentally ill and need help badly. I know that Transitions works very hard to try to maintain the best they can and do the best they can there, as well as many of these other things. It is imperative that they have something like this for those who are getting out of, they're aging out of the process of being in a home. But that does not mean they're ready to enter into a neighborhood where people are feeling at risk already because of so many places near them. And so I'm in opposition because this is not fair to the businesses and the people that are already there and trying to rebuild a neighborhood that this will not be a benefit to them. And I thank you for your attention.
Thank you. Anyone else?
I'm Naomi Gilliard, and I reside 1409 Cherokee Street, right off of Washington, right off of Hampton Street. I oppose of the residential construction that has been planned for Washington Street. I believe that we are not going to benefit anyway, and that we should just look at what is going to impose on the neighborhood. The neighborhood is not in the very best of condition as it is now, and this will not help the people who reside in our neighborhood. I've been a residential person here in Columbia for over 50-some odd years, and I've seen it go from leaps to bounds. Why make our neighborhood and the people who live in our neighborhood a guinea pig? That's the way I see it. We would only be a guinea pig for those persons who I know they feel like they are trying to be of help to our neighborhood, but they are adding on more problems that already exist. We look like, where I live at, it looks like it's a wilderness. It needs, they can hide behind trees and start fires, and all kinds of things now exist. So all of these things should be taken into consideration before we start adding on more buildings, whatever exists, making more problems in our neighborhood. I too am an educator, and I have seen things right on my street where I live at that should not be. And I'm not going to go into details because it'll be too humongous for, and a lot of things has already been mentioned, but we need to take a lot of things in consideration now before we build this building, because it's going to be a lot of bad problems that exist. Okay? Thank you.
Thank you. I want to say we've heard a considerable amount of evidence about the problems in the neighborhood and about what's there and how people act and so forth. I don't think we need to hear any more people saying the same thing. So I stress, if it appears to be repetitive, I'm going to ask you to either say something different or to go sit down. Okay? Thank you.
My name is Elizabeth Marks. I own property at 1908 Henderson Street. I'm also president of the Robert Mills Neighborhood Association, and I'd like to talk about the impact on economic development. We've been working very hard to bring up the Hampton Street corridor, and I would like to say that the proximity diagram is incorrect. I drove this area myself, and actually the facilities are much closer than it shows on here. 2 city blocks equals approximately 1/10 of a mile. So within 10 city blocks, we're talking about Cambridge House, Christ Central, Hannah, Transitions, Alston Wilkes, and the Oliver Gospel Mission. When a business looks at our area, one of the things they're looking at is who their neighbor is. If you tell somebody that their neighbor is going to be a halfway house or a residential facility, or particularly a mental illness recovery center, it causes them to pause. We're really glad that the United Way has moved into our neighborhood, and they're doing a beautiful job. They're on the other end of the neighborhood. They're on what we would call the restored end of the neighborhood. It's close to the new beautiful Bull Street development. So you're talking about a facility that's moving into an area that we've already restored. This facility wants to move into a part of the neighborhood that we haven't restored yet. So we do believe that it's going to be detrimental to other development in that area. The density is too great. Our neighborhood is where the city has parked the people it wants to hide for decades. And we've borne that burden, and the lack of development, particularly, and the resistance to development on Hampton Street has to do with the proliferation of these businesses. You approved a residential care facility for the Mental Illness Recovery Center in October on Hampton Street. They already have a facility on Gregg Street, and they want to put one on Washington Street. So within one block area, there's potentially 3 facilities that will be running programs for mental health recovery within one block. And that doesn't include the fact that you've also granted them additional parking to expand their program on Hampton Street, which you did at the last meeting. So I think we've carried enough of the burden, and we oppose this. Thank you very much.
Thank you. Is there anyone else?
My name is Wanda Gale Breedlove. I own property at 1414 Gregg Street, which is around the corner from 1813 Washington Street. I also own a property at 1401 Laurel Street in the Robert Mills Historic District. I have been at the property working on it, living there most of the time on Gregg Street until I bought the other property for 36 years. So I've seen a lot of things happen in the neighborhood during that time. My own property has been rented out as a business. It's been rented out to university students. At one time, I rented to AIDS sufferers. But most of the time, I lived there myself and worked on the property. I've seen a lot of changes. There was a time when I could work outside. And I want to speak directly to Mercy across the street from me, which is already in existence. And although I mentioned this at the last hearing, according to my notes, 2 of the 4 members here were not at that hearing. And so I feel that it is appropriate to repeat that one thing. And I have several new things which have come to our attention since other members of our community have learned and become involved in this issue. What I would like to say is that I, like my neighbors, was thrilled when this wonderful new building was being renovated and put in on Gregg Street. I was so relieved because we expected good things. What we got was an increase in the number of people sleeping all over the neighborhood and waiting to go into the Mercy facility and sleeping on the Mercy facility to do so. Mercy's response more recently in our hearings has been, yes, but we've become offices. We have since learned with further investigation that they're offices. They are also providing services, and they have a clinic there which explains the large number of buses already on Gregg Street for clients going and coming to different operations, which has been a traffic congestion there. Another concern of mine has been last summer when I was painting my house on Gregg Street across the street. At one point, there was such a loud, disturbed person in their parking lot, which fronts Gregg Street. Their building is back further, which went on for hours. I became frightened and I went inside. Unfortunately, my cell phone was out with my bucket. Numerous members of the Mercy staff walked in and out of that parking lot, ignoring this person. I kept thinking, surely the police will come, surely someone will do something. After hours, the man finally went in his disturbed fashion down the street. Also, I have learned from my other neighbors the kind of responses that I got this past week in a neighborhood meeting when Mercy said they were there to answer our questions and work with us. When I attempted to ask questions, they had tried to get me called out of order for answering questions, which is why they said they were at the meeting. Other neighbors have found that, for example, the wall which fronts their current office and a parking lot adjoining it are having some issues. Instead of working with the person who has this problem, they called in an engineer in and paid them to blame the problem on the property owner. Another of our members in the neighborhood has rented a facility to Mercy in the past for one of their apartments. It was trashed, thousands and thousands of dollars, which they have never recovered. Now, again, I am not addressing the program. I am simply addressing, as a neighbor, we have not found them to come to us or to meet with us or to talk with us unless they have already a full-blown proposal and they simply want our endorsement not to work with us. I want to address from the application a couple of discrepancies I noticed that might be of interest to you, because I don't understand them, and perhaps without your familiarity of the area, you may not know them either. I'm looking specifically at some of the addresses in the document. So that it says here that they have submitted a special exception application for this same project at 1819 Gregg Street. I don't know anything about that proposal or project. I don't know if you do. It says that they're going for 3 parking spaces. I see that they do have 5. It says that they're going to house up to 12 residences in a 2,500 square foot building. Obviously, there are going to be kitchens. There's probably going to be a meeting or treatment area. I would expect there to be some bathrooms. How much square footage does that leave? And each of these persons are to have separate bedrooms. From my experience in education, putting this many people of this age in a very small confined space is going to be problematic. And we don't have any indication of the what these bedrooms are going to look like or how that's going to be managed. Another concern that we have had with programs in the past, we have had a lot more serious problems since the various facilities that the city was co-sponsor of in our neighborhood. What happens when these students are discharged? If they follow this procedure, which is true in the schools too, and they have a procedure, eventually a deputy has to come in the classroom and bring those students out. Well, what happens when they're out? What has happened to our neighborhood in the programs that have gone away, when they're not eligible to sleep in these facilities or when they are kicked out, they have come to know our neighborhood. And so it keeps adding additional elements to what is already a serious problem. That's been addressed, but I'm just saying when these programs kick somebody out or when they're not eligible and their friends who visit, it keeps bringing more and more people from all over the city aware of where they can get drugs, the damage they can do in our area. I want to address on page 13, I'm not certain, and I'm sure it's clear to those of you who are accustomed to studying these more often, the picture at the bottom of the page does not look like the other pictures. I can't tell if this is supposed to be an example of our neighborhood. I don't recognize it. I don't know if it's supposed to be a new facility. This is to show what they look like. But I've spent a lot of time trying to save old houses. The 4 at the top don't look like this. If this is the kind of look that they're proposing, then it would not be, and I can't tell. I don't know, and I don't know where it is or what it is, and perhaps you do know that. But it was not clear to me. They also indicate on page 16 that a special exception was granted for 1433 Gregg Street. I would like to know when that was approved and what that is, because again, this is more information that we do not have. I'm also concerned.
Ms. Breedlove, just a
Yes.
moment. This is, as I understand it, was a special exception was granted, but for economic reasons it was abandoned. Is that correct?
I believe that was at 1819 Hampton Street.
I'm just trying to clarify.
Yeah, I'm sorry.
The staff, thank you.
Correct. 1819 Hampton Street was a special exception that was approved in 2015, but it was abandoned.
Right.
For financial reasons, according to the applicant. And perhaps in the applicant's rebuttal at the end of this, maybe they can answer some of the specific questions that have been raised.
To address the Gregg Street, and which is, what address did you say they're referring to for Gregg Street, Ms. Breedlove?
It says here in the document that they presented to you for your review, that they have a special exception granted for a project at 1433 Gregg Street. This is on page 16 of your document.
Okay, I see there's a staff note indicating that there was one on Hampton Street, not Gregg Street.
Correct.
Okay. So we will find out. The better person to find out what's going on is the applicant. Thank you.
We have done investigation into the exception that was given to 1819 Hampton Street, which is not mentioned by address or title in this document, and they have until, my understanding is, December of this year in which to continue that. Not only that, since the exception has been approved, another similar organization could come in and occupy that same special exception. So again, we have 3 existing footprints in one block, the potential with your today of a 4th, and on the committee today, 2 of the people here voted against allowing it on Hampton Street in the beginning. That was last year. I also want to share with you some percentages that I have put together from looking at each of the properties and their services in the neighborhood. On some of the frontage streets in that one block area, we have up 67% social services. Another one of the streets has 55% social services. If you take the entire block, it already has 35% social services. They do not need special exceptions. They may be attracted and more businesses may leave or not join us, but to give special exceptions in that high a concentration, and to use a term that you shared with us before, LULU, locally undesirable land use because of the concentration here in this one area. Certainly, we understand that nobody wants these in their backyard. I'm sure there is not a line of people who want to do this, and we might not be an exception to that, but the concentration is our primary concern, and the kinds of issues that we're already dealing with, that has already been covered. Please don't let me get off on that, I apologize. What is it that we want? We want the same things that you want. We want the same things that Mercy wants. What we want is we want a good, safe city for us to live in, a place of opportunities, a place where we help those who need it. So we are not talking about those kind of issues. We're all trying to achieve the same things. We may disagree on how to do it, or where to do it, or when to do it, but it's not because we don't want all of those same things. And we have those same commitments in our neighborhood. I would simply add that we don't want to have a straw that breaks the camel's back. We want to work to better our neighborhood so that you don't have to pour funds soon into our neighborhood because things have gotten worse. Thank you for hearing our concerns and questions. I would like to ask, we had a number of letters of support. I wonder if you had an opportunity to read those before the meeting began.
Were those in the file? The letters?
Those were handed out. Actually, yours might be in that spare binder.
Okay.
My concern is if you have not had an opportunity, because they address different issues from different perspectives. They are businesses in our area. Some of them are directly, and there are at least 4 such letters. And we would like to have a hearing of those points, since those people had appointments or obligations which they could not change, or they would have to be here and to have your attention.
Thank you. We've now passed the 1 hour mark, so I'm going to really start imposing time constraints, particularly for repetition. Is there anyone else who would like to speak in opposition to the application?
In respect for your 1 hour, I certainly agree. I apologize to those people who attended today and are at this point showing some boredom because this has gone on so long. I suggest that this may be more critically important to these ladies and occupants of the neighborhood than some of these other issues that may be less personal. I made a number of points, and some of them are repetitious. No one here is opposed to what Mercy's mission is. Their own website says that they assist the mentally ill. I'd suggest that perhaps the fact that they abandoned the other project where they said that it was too expensive to renovate, they might wait until this building is designed to find out how much it's going to cost and have a relevant comparison as to where it might be most advantageous to them to develop. However, while I was sitting over there in that pew, I decided perhaps the single most important point I could make to you today. I have heard people speaking over and over again about the prevalence of homelessness in this neighborhood, the use of drugs in this neighborhood, people sleeping on porches and people sleeping underneath houses and all in the neighborhood. And you would have every right to say, well, what does the existence of homeless in this neighborhood already have to do with a mission that is here to reduce homelessness? And I would go directly to that point. I was privileged to be in the meeting where Ms. Avon came and made a presentation, and she said that it's going to be a very strictly run facility. There'll be discipline. There are strict rules. And whenever this happens, we know there are going to be some dropouts. And it's these dropouts that continue to add to this homeless issue in this neighborhood. The only real issue that I think you have to decide on is the density. And when you look at the map and you look at the density of social services in this neighborhood, these people are carrying the burden now. I'd invite you to come to Lakeshore Drive, where I lived until 4 years ago, and try to get this passed, or to come to University Hill, where I live now, and try to get it passed. These people have a stake in trying to preserve their neighborhood. We've seen neighborhoods come back before. A neighborhood can be saved, but not if we continue to put this kind of burden on them. I appreciate your time. Thank you.
Is there anyone else in opposition? Would the applicant like to respond to some of the points that have been made? What? Speak at the podium.
Only if you have questions, but the only thing we could just clear up, I guess, is the reference to special exceptions in the packet. That's just a typo. The only special exception we're referencing is at 1819 Hampton Street.
So that was just an error, right? I want to clarify a little bit. Depending on which of your conceptual site plans we look at, there are a number of parking spaces that seem in excess of what you would need for staff and people coming in. Are any of the residents allowed to have vehicles?
Yes, I believe so. That's the parking meant to address. And just as far as count, the parking's based off of just zoning, so per bed. So based on our number of beds, we require 3 spots.
I doubt seriously that any of these guys are going to have vehicles. Our experience with the 300 folks that we currently serve, very few have a car.
But some of the residents might have to have parking, is that correct? If they do have a car, they would have to park it, right? As I understand, the neighbors are saying they do have problems with on-street parking.
On Washington Street? I mean, I park there when I go see Mr. McLaughlin and stuff. There's not a limit to parking. We're doing the number of spaces that we're required to do under...
Well, the application is for 8 to 12 residents.
Mhm.
So, you know, if each of them have a car, then obviously you're going to have I think it's unlikely again that.
They're not each going to have a car, and I would think that if we wound up with a bunch having to do that, then we'd have to arrange to do some leased parking for those young men somewhere to keep their vehicles. They wouldn't be able to keep them.
All we can really respond to as architects and designers is to address the required number of parking, and we've exceeded that. By
One
a
of
factor of 50%.
the residents have said frequently, and there was comments today, that this should be somewhere else. Why this location rather than some other part of Columbia?
Mercy owns that property.
In addition to that, too, I mean, obviously financially it makes sense because they own the property. But beyond that, in our conversations with zoning staff, C1 was recommended to us. As we've spoken to in the past, it is important to have proximity to other services and amenities. The individuals here are meant to be productive 40 hours a day or a week, which is part of their program. So being close to other partners and amenities where they can do that. Transit is just it's a good fit for the project. It fits well within C1, and the proximity values are important.
I have a question. Somebody, I believe the last person who spoke in opposition raised a point. Have y'all run the numbers on this facility?
Yeah, we've got an estimate based off, and just to outline our process, just being mindful of Mercy as a nonprofit and being respectful of their fee. We wanted to limit the amount of work we're doing prior to knowing we could do the project. But having the benefit now of having gone through that process once, we do have that estimate. The LCK is a project manager on the project, and they've actually worked with a developer who was able to do an estimate as if it were a new project, and the estimate came back to fit well within our budget.
So this isn't a case if you were to get approval to get the special exception that you might not move forward with this site.
I mean,
and then that piece of property have that use.
Yeah, we wouldn't anticipate so. I mean, existing infrastructure. So looking at our current budget and what we have, we're I guess probably 10% under our budget as far as what the estimated value of the building would be. And as a firm too, we do have experience in similar construction types and size buildings, and we actually just recently completed one for Family Shelter over on Two Notch, which was at the bottom of the page. I mean, that was effectively the exact same cost per square foot that this would be. So we're fairly confident that we can fit that within the budget.
A question came up about the images on page 13 of the materials you supplied.
Yes.
There are 6 pictures. The top 4, are those to be are meant to be representative of the neighborhood?
Mm-hmm.
Do you think, and what are the bottom 2 supposed to be?
The bottom 2 pictures are just representative of a recent project that we've completed that is of a similar cost per square foot and material type. Whenever you get into aesthetics, I guess there's a degree of subjectivity there, but we feel that the craftsman style aesthetic with the brackets and the brick base and the hardy plank siding, is fairly similar to existing.
I guess where I'm going is the picture in the lower left does not look at all like the pictures in the top 4.
Well, I mean, if that's the feeling of the board, we're happy to create the building in a style that's consistent with the top 4 images.
Again, I think
the intent there is just
the objection of the neighborhood is, as I understand it, and Ms. Breedlove was pushing it. There are a lot of social services agencies in the area. If you were to get the exception, the very least you could do is look like a house in a regular house, rather than look like yet another institutional facility. So I guess looking at aesthetics and the impact, normally we don't do design concerns, but
Yeah, I mean, obviously, it's not a criteria of this meeting, but it is something that's important.
well, aesthetics is a criteria, but specifics we don't usually do.
Sure, and in the criteria, we've outlined that it would be a two-story residential type historical style structure, which is something we're committed to. And I mean, as architects, it's important to us that this building fits and looks nice in the neighborhood. I think we're a talented group, and we've got the ability to do that. I don't want to hold too hard on any one of these images, but again, like I said, we're confident this will feel and look very residential. It'll be fitting, with materials, and if there is a framework for some sort of review, we would welcome that. I think any kind of review process with the city is always beneficial, whether that's DDRC or some other staff review of some kind. But we have no issue with that. I mean, we want it to fit in just as much as anybody else does.
Let me ask the staff a question. I'll show my ignorance. So, if they get this special exception, who approves what it looks like? I mean, I see the residential cues of like a Shandon type house with the roof line and stuff like that, but does this go in front of DDRC? What body does it go? I mean, they're not building a house, and I recognize that, and I don't think they should be required necessarily to build a house, but they shouldn't build something that, that screams commercial in this district. I understand it's C1, but what body do they have to go in front of to have the building approved?
It would just be a staff approval. It would not go to a design review commission or any such body. So we would look at the site plan relative to parking, landscaping, and building code, and that would be all the review that would be.
Is that something,
Are you saying
I don't
if-
know that it's equitable
if-
to have their design open. Is there a way for the public to collaborate? Is there a way for them? I don't want to tie them because architects and contractors do what they do, and as a member of the general public, I don't think it's my place necessarily to impose some kind of undue burden on the applicant, but is there any chance of collaboration, or is that just the applicant comes to you with a plan and it's thumbs up or thumbs down?
Sure, it's up to the applicant if they want to take input from any of the neighbors. The board, within reason, can place any condition on their special exception approval that they deem reasonable, but generally speaking, as far as architectural review or design, we really wouldn't get too involved other than the basic zoning requirements, unless, again, the Board of Zoning Appeals puts a criteria on the special exception, should you be inclined to approve it.
Okay.
And we welcome that as well. From the community or staff or and any other framework would be helpful to us. I mean, that's something we all enjoy as designers. But just speaking to the residential type, I mean, what we priced was a two-story building with a porch, with a gable end. It's hardy plank, painted siding and a brick base. So with columns on the front of the porch. So I think as far as just a general residential framework, I mean that is what we intend to create, is effectively a house. I think that's how it will be perceived in the neighborhood. If you drive by, I think it could easily be mistaken for a house. Particularly if we have a contingent piece put in the parking in the back and you won't even see it.
Are there any other questions for the applicant? Thank you very much.
Thank you.
At this point, we're going to close testimony and go to board discussion. I want to start with a question to the staff. I wasn't sure where we ended up on design. It appeared to be that you were saying it was not feasible for the staff to be involved in reviewing the architectural decisions that they made, so that whatever their good intentions are today, if the budget got tight and they built something else, there's nothing that we today can do to prevent their desire to build something else. Is that correct?
Unless you made it a condition upon the special exception approval, as long as it meets the basic zoning district standards as far as any other development, again, setbacks, landscaping, et cetera. We wouldn't get into the design specifically.
So you do not, you would, again, I want to make sure we're going to, no matter what we might put a kind of condition on what the building might look like, that would really not be an enforceable condition.
Correct.
Thank you.
I think, just to interrupt 1 second, I think Andrew had an announcement about a car that might be getting ready to get towed. A black SUV parked in a reserved spot, Suburban.
Yeah, that's me.
Okay. I know that was so.
I'll go move that.
We can't lose a quorum. We're not going to lose a quorum. Is there something else that can be done?
We can take a.
Tell him not to tow him.
Thank you. Okay, any discussion? Do I hear a motion?
Just curious, Pat, what your thoughts are. I mean, I have some. I'll tell you what I think. Yeah, I think what we are talking about on some levels of concentration is it's always interesting to sit up here and hear both sides of it and, to see who's in support and who's in opposition. This is a C1 district. There are residents that live in that area. And, knowing the different services that are spread throughout this area, there are going to be problems. I've seen it. I had a little men's group that used to meet at Nathan's up on the corner, and, we'd meet at 7:30 in the morning, and you see it. The flip side of it is you've got 600, the economic piece, you've got 600, I think, new beds coming in on that blighted corner of, where the old bus stop was, on the corner of Gervais and Hardin Street. And I think there's been a confidence in this area. You've got a bed and breakfast, you've got the law firm that dumped, a ton of money into the old Lorick house, knowing full well, what's going on in that neighborhood. You've got the person who came who, I guess, kind of, the Barnwell Street apartments with a bunch of kids, who's in favor. I see JT, and then I see the other side of it, Mr. Pride, but I don't think the city tries to hide. I've got a family member who suffers from mental illness, and I'm grateful that we've got the resources, to try to get him some help. And so I think it's a very important purpose that Mercy serves, but I get the Lulus and the NIMBYs and all the other terms you want to throw about, but I'm in favor of this. I think it's a good organization. We can't condition up everything. I do have some concern that it's going to look like, I went to my first Fireflies game last night. I don't know who was in charge 25, 30 years ago, but I've never been past the Babcock building, and what's in the back, you've got these old buildings, and then you've got that newer thing on the corner of, well, not on the corner, but Calhoun Street. So I am concerned and would hope that Mercy is going to live up to what they said on the record, which would be to build something. They can't build it like we would go out and hire an architect and build a house in whatever neighborhood, whether you're in Old Shandon or Lake Catherine or Northeast Columbia or what have you. I think the best they can do is do the cues of porches and windows and things like that. So, and I respect, I forget how long I've been on this board, but I really respect the people who take the time and have the heart to go get invested in their neighborhoods. I live in Lake Catherine. We don't, we don't have the Mercies of the world coming in. So I'm very sensitive to the fact that there are people who do feel like they're dumped on. But I just think there's a lot of good going on in Columbia, and we've, this is just part of a growing city. And anyway, I'd be interested to hear what my other board members think, but I'm in favor of this special exception.
Calhoun, everything you said, I totally wholeheartedly agree with. We can't save everyone, but with the things that we have there, I mean, we're right next to one of the most greatest institutions. We have Benedict College, we have USC. It's like right in walking distance. And I think you're right. Nowhere, I think in particular, would be perfect for something like this. I don't know if that was a motion, but if that was a motion, I want to second it.
Was it a motion?
Was it a motion?
Well, I mean,
Why don't you state it as a motion?
gather up my facts. Digital's great when it works. I'd like to make a motion to approve the application for special exception, case number 16-038-SE for 1813 Washington Street. It's my opinion that this meets the 8 criteria that are required for a special exception. I don't think that the proposed special exception will have a substantial adverse impact on vehicular or pedestrian safety. There are no environmental factors. Aesthetics, I think we've been over. I do think that I've got a confidence in the city staff to protect the public like they do. The impact on public safety, nuisance, I just don't think that this facility creates that. The concentration, I recognize that there are other organizations in the area that do somewhat similar, that provide somewhat similar services, but I don't think that there's a concentration that's going to be detrimental to this area. It is consistent with the character. Given the zoning district that this property sits in, I think it is compatible, given the other service providers that are there. And I do think that it's also compatible in light of the residential component of this area. And then, the one that I always struggle with, public interest. In my opinion, there is no adverse impact to the public interest. So I would make this special exception and make it contingent on any, I don't think the staff had any, that it is contingent upon that it is subject to, rather, the 3 conditions that the staff has in our packet.
Second that.
I'd like to speak in opposition to the motion as to a couple of problems in terms of the criteria, as to aesthetics, as to off-street parking problems. Basically, we're relying on the goodwill and confidence of Mercy, and that I've done a lot of zoning in nearly 40 years here, and all the best intentions in the world, things change, and then, sorry, we just can't do that. And yet I've been told we cannot come up with any conditions that would protect these concerns.
Let me ask a question. Can we not, let me be certain that I understand what you're saying. So we can't make a condition that none of the residents have the ability to put cars on the property?
Well, I would want to do the opposite. I would want them not to be parking on this street.
That's what I'm saying, is to have a prohibition.
That nobody can have a car? What if they have a job and need a car? I don't.
Well, I think that the applicant stated that they would have to go lease parking. And in my mind, that means that they cannot have a vehicle on site.
Well,
So-
I think she said, my understanding was if the number of parking places on site, then they would have to do it. But again, we're relying on when that comes up, that
Not
that
if
will
we-
indeed be
well,
done.
Could I ask a question of the applicant? I mean, if that's a condition, Pat, that's pretty severe.
Well,
in
that's
my
just,
mind-
I want to stress, I've been told by the staff that there's nothing we can do about the appearance of the building. And to me, that's at least, if not more important than that. I think certainly, though, if you want to hear what the applicant would say to the question, they're ready to answer you.
I guess, well, let me address two things. Is what I thought I heard you say was that we can't put a prohibition on. I mean, certainly we can have a prohibition that says that this special exception is hinged upon that none of the residents can have vehicles on site. And the reason why I bring that up is that the applicant stated that if that was an issue, that they would have to go lease parking. And in my mind, the logic says that you're okay with people not having, with residents not having transportation there. I mean, I just want some clarity on that. I mean, I understand that we can't dictate what it looks like, but I don't think we can, you know, if somebody else pops up with another use, it might not be a social service, a law firm, we can't. Anyway, I just have got a question about the parking for the applicant. So would you be opposed if there was a prohibition against residents having the ability to park on site? Well, I don't think we can prohibit people from parking on public streets, but I'm talking about, I think what Professor Hubbard is raising is a concern of, I suppose, vehicular and pedestrian safety. I'm not sure which of the criteria, but
As I understood it, and there are areas there, and again, we're talking a lot of vacant land to some extent, so it's easy now immediately in that area to park on the street. But it was testimony to the effect that in other parts of the neighborhood, off-street parking is a problem. So if on street, it's hard to find a place to park on the street. Well, given...
I think, you know, on-street parking being, you know, busy, I mean, I had a hard time parking when I came to this meeting. I think that's just a reality of any urban condition. But to specifically address it at our site, you know, if that's a contingency that we could add, I mean, you know, I don't want to speak for the owner without discussing it, but at the same time, you know, we have our parking on site where we would provide parking for residents, and through their experience are confident that that's adequate, and that's also more than adequate than what was required by city zoning requirements. So if in any event that there's a time when they're serving these individuals and they have more cars and they have space that's allowed for, then it's up to Mercy as an organization to make sure those people have a place to regularly park. And
right,
I would assume that they would.
But that's where you lose me, where I go back to Dr. Hubbard, is what he's doing is trying, which I understand, to prevent something. It's not that we don't trust you, but that we don't, this is the point in place where we can have an impact on preventing issues like that.
I don't think Mercy would want their residents to rely on on-street parking. You know, I think, you know, they've already said that they would provide lease parking. I mean, I think it's the best we can do. The which we've done.
But if that was a condition, let's wrap it up with this. Are you opposed, if that's a condition that we impose, do you have a problem with that?
I don't have a problem with, you know, if we've got 5 lights and because guys have a vehicle, we're going to need more than that, then we'll lease more parking for them. But what I don't want is for the young men that live there to be treated differently than anybody else that lives there or works there. You know, it's our goal that these folks will stay there, finish their education, get jobs, and be ready to become self-sufficient. I think a part of that may be saving the money and purchasing a vehicle before moving out on their own. So if I have a guy come home from work at lunchtime and pull up in front and park in an open space, I don't want a neighbor calling me saying that my guys are breaking rules.
I think we could certainly have the lease parking just so it's available, you know, so they don't have to park on the public street, but it may be an odd precedent, to be honest, to restrict, you know, a business owner or a member of an
Right, but we routinely, I mean, there was something on the consent agenda where a business is gonna, and y'all are a business, or it's gonna have to provide valet parking, and it's not uncommon for, for a business, particularly in 5 Points or different areas where you have to provide. And I think the concern is that if you've got 12 clients and on the off chance that everybody has a car, and I know that that's an unlikely occurrence, but it's still something that could happen, it presents a problem. And so just the question is, and I think you've answered it, if the granting of this special exception comes with y'all having to lease parking, you're not opposed to doing that. Okay, thanks.
And coming from
We
the
would
guy,
only have to lease if we needed it. I mean, I don't need to go out and pay for 12 parking spaces forever if nobody needs them, right?
About this.
I mean, if you work downtown,
About
you
this,
you
I've
go
made-
lease your space,
I got you.
right?
I've made a motion, and I probably interrupted Mr. Hubbard, so why don't you finish? And I'll-
Have you had your question answered?
I've had my question answered, yes, sir.
Thank you very much. I will resume my objections to the motion. I repeat, we're relying on, and it's not a question of, again, my point is there are good intentions, things will happen in terms of potential problems of parking, aesthetics, in terms of how it's going to fit in. We have a serious problem, I think, in terms of the concentration of social services here. And it's sort of ironic when asked why this location, there were 2 reasons. One reason was they already own it, so it's cheaper to do it this way. The other was that it's convenient to social services to help them. So we have this sort of idea, because there's a concentration of social services, that becomes a reason to have yet another social service. So it is kind of an interesting potential spiral here. And I think we do have the problem with the concentration as well. Again, the very idea that picking the location, because it has a good concentration of convenient social services, sort of raises part of the problem. I will put myself on a time limit. I just think the neighborhood has done more than its share of handling these kinds of services. I think it does hinder the development. They have worked hard to have some positive development despite these problems. But where we're going is the classic problem of death by 1,000 cuts. No single one of them kills you, but eventually you bleed to death. So I'm opposed to the motion. Any other comments?
I'd like to make a comment, and coming from the guy that parked illegally, I don't know if I should talk about parking, but I'm encouraged the fact that the neighborhood came out today and voiced their opposition, and I appreciate you taking the time to do that. Having said that, just looking through the lens that we're required to look through, which is the 8 criteria for this special exception, I tend to agree with Calhoun, and I would support his motion.
Well, 3 of 4 have expressed support of the motion. Shall we vote? All those in favor of the motion to grant the special exception, say aye.
Aye.
Those opposed, no. The motion carries 3-1. Where is Mr. Sally? You can ask the staff a question.
Take a 5-minute break. We're going to take a 5-minute recess. That was a tough one.
It was.
Yeah, give it to Andrew. They'll pass it out.
I'm fine. How are you? It's good to see you again. Oh, God.
What's happening? So JT said he was. Well, then why did JT come?
No, I know what she said.
She's against the.
Okay. They came for actually there when they had crime that they're doing. So she said, man, we saw JT. JT was for it.
That's what I'm
I
saying.
That's what I'm saying. I don't know why she was there.
I'm gonna look. No, I think what happens is, what I would not say this to her. I would not say this to her only because she get your back straight and then stand strong. But then don't get mad when somebody questions you. That's what I'm worried about with her, is that she doesn't seem to be open to outcomes. I just have a hard time thinking that. I mean, JT was just here.
Yeah, I know, right? Yeah, I didn't look at it. I didn't read the whole thing until you told me that. Yeah.
Dude, it's all right. This could really get me in trouble, and I'm in recovery, so with apologies to any other drunks out there, this is what I call arguing with the drunk at midnight. You know, all you're gonna do is hit somebody with logic 99% of the time. You're gonna piss the drunk off, and you're not gonna change their mind. So why bother? Yes.
Well, we did have to. Took us a while. You're preaching to the choir. Have a good day.
Dang.
Well, yeah, let me show you what, here's what we got. This is probably the furthest out we have, but I do also have a link to, and unfortunately I won't be able to use that, but I do have the link to Google.
Right.
So I can.
That'll help. I really
Got
wish
a
I'd sent it to you. It's
I've got a
video
child
anyway,
with
so
special
we don't
needs who
know.
suffers from mental illness, and I don't want to,
Well, you know, if you want,
I
can
can't
go
argue
through
with
that.
you, but I think that, I don't disagree with what you're saying. But I think a big problem has been in that area is, and however it got passed, is take it up with the city or the county. You had the county dropping off people coming out of the Alvin S. Glenn facility. I'm just saying that area has been dumped on. But you've got the parole office, and then you had, I mean, I don't think people realize that had before that student housing project came in, people that got out of the Alvin S. were dumped.
358 days a year. Been around this area. Man, that's what we got.
Yeah, so what you can do is when you're
Okay, Google is not as good as this. I wish I'd have known that we could. I only thought we could submit
right, yeah. So you know, I mean, everything that was an image in your application got in there, and then you know, we have a percentage.
Well, if you can help me, I mean, I think at least it shouldn't be too difficult to illustrate. I mean, there's striped parking down National Guard Road. This is Berea Road, parking on both sides of Berea. Maybe if they want, I can email it to them.
terrible, wasn't it?
Uh-huh. Yeah. Okay. Okay, I'd like to go ahead and reconvene the meeting. Okay, so I think the next item on the agenda will be 16035AA, a administrative appeal, 4701 Divine Street.
Correct. That appeal, again, is at 4701 Divine Street. 1381402 and 10 is the tax map number. Basically, what we have before us today is the appeal of the zoning administrator's determination regarding repairs to a non-conforming structure. So, in essence, the Board of Zoning Appeals shall hear and decide appeals when it is alleged that there is any error in any order, requirement, or decision or determination made by the zoning administrator in the enforcement of the zoning ordinance. The applicant does allege in the application that the zoning administrator did err by refusing to issue a zoning permit for reconstruction or repair to a damaged structure. The structure in this case, again, is located at 4701 Divine Street, also known as 700 Croson Road. The damage to the structure was due to the October 2015 flood event that we had. The use as a non-depository credit institution and the actual structure, the setbacks are non-conforming. So really what is before us today deals with the structure more so related to the setbacks off of Divine Street for the structure. The intent regarding non-conforming structures is that with, again, referring to the zoning ordinance, within the districts established by this article or by amendments, which may later be adopted, there exist lots, structures, uses of land and structures, and characteristics of use which were lawful before the ordinance from which this article was derived and was passed, or before an amendment to this article was passed, but which would be prohibited or regulated and restricted under the terms of this article or future amendment. It is the intent of this article to permit these nonconformities to continue until they are removed, but not to encourage their survival. Nonconforming uses are declared by this article to be incompatible with permitted uses in the district. It is further the intent of the article that nonconformities shall not be enlarged upon, expanded, or extended, reconstructed to continue nonconformity after major damage, or used as grounds for adding other structures or uses prohibited elsewhere in the same district. Another section, 17202F, refers to continuance of nonconforming structures and uses after damage. Specifically, it refers to reconstruction after damage. A nonconforming structure shall not be rebuilt, altered, or repaired except in conformity with this article after sustaining damage exceeding 75% of the replacement cost of the structure at the time of damage, provided that any permitted reconstruction shall begin within 6 months from the time of damage and shall be completed within 12 months after the issuance of the building permit. So if staff uses the date of approximately October 5th, 2015 as the date of the flood, on or about April 5th, 2016, would have been since 6 months since the damage. The owner did not contact the zoning office until 29 March 2016, inquiring about permitting for the structure to be repaired. Again, that was nearly 6 months, a week or so short of 6 months. The applicant was aware of the issues with the structure in December 2015. The Columbia Police Department Code Enforcement Division issued a notice of order to demolish and remove the structure. March 16th, 2016, the Columbia Police Department Code Enforcement Division issued a notice of correction order advising the owner of serious code violations and describing the property as an imminent danger. As we can see by the photos that we provided, it at that time and in December was a serious code violation as far as safety to those in the area, and in fact, it was appeared to be, hanging over Gills Creek, unsupported. So there was that safety issue as well. So March 29th, when the owner did contact, that same time period, this office spoke with the owner, set up a time to come in and talk about the repairs to the structure. 6 months would have been April 5th. The staff that we needed to gather, which was the flood permitting staff, the building inspector, stormwater folks, it was a good many people, so it took a little while to gather everybody together. So we met on April 14th. Again, that would be 6 months after the flood event, but we extended the deadline until May 1st because getting the city staff together was basically something that took about 2 weeks, as the load of work for everybody dictated that it would take a little time. So I extended it until May 1st, again, in good faith effort to have the applicant provide the information that we would need in order to make the determination of the damage to the building. So if we go back to the damage exceeding 75% of the replacement cost of the structure at the time of damage, that was kind of the figure that we were looking for. We were provided on April 28th, again, 6 months after, the flood event was April 5th. April 28th, we were provided an appraisal and estimates of the cost to repair the damage to the structure. The appraisal was from Rosen Appraisal Associates. What was given in that appraisal would have been the replacement cost to build the structure as new. Staff also received an itemized estimate of work to be completed from Glenn Weaver Construction. In staff's opinion and the professional opinion of colleagues at the City of Columbia, the estimate repairs seem to be incomplete and not an actual accurate reflection of the actual damage sustained. Again, as an example, on the estimate under HVAC was listed $1,000 labor, $500 material, no mention of the actual cost of a replacement, heating and air unit. No mention or a low figure on the roofing, exterior lumber, hardware, cabinets, plumbing fixtures, paint, drywall, lumber, and exterior finish. AOS Specialty Contractors provided an estimate to stabilize approximately 50 feet by 16 of the creek bank behind the building. The owner representative emailed that Mount Valley said the cost would be about $8,000 to repair the foundation, but no formal estimate or plan was submitted. No structural details were provided to address the fact that the entire rear of the building was and is hanging unsupported over Gills Creek. No information was submitted to this office that concretely provided the actual flood damage value sustained relative to the replacement cost of the structure at the time of damage. This office requested and was not provided a copy of the insurance claims report to assist in the damage estimation. The submitted contractor estimates for repairs, again, was insufficient. This office provided estimate for repairs, but not an assessment of the actual damage. The actual damage incurred in this case was unclear because no insurance claim or other independent adjuster estimate of the damage was provided, nor was staff given concise information to make a reasonable determination on the damage to the structure. So, in closing, our goal as City of Columbia employees is to get people permitted, to get what they need, regulatory speaking, to get a permit to do the work within the bounds of the zoning ordinance. It's not our position to make things difficult. We try to enforce the ordinance in a reasonable manner, and when we ask for information to make an interpretation of what we need to make that interpretation, when we ask for that, is not given to us, it kind of leaves us at a shortfall to actually make an accurate determination based on the requirements that the zoning ordinance and city council require us to make. So staff would respectfully request that the determination not to issue any permits for the structure located at 4071 Divine Street, also known as 700 Croson Road, be upheld. And the applicant is here for the presentation and can answer any questions.
I have a quick question, staff. So, just so I can get it clear in my mind, this is a non-conforming use. Explain. I mean, what part of that is it? The building not be able to be constructed back because it doesn't fit the lot, or because of what it was used for, or what was the non-conforming use?
So we're not so much focusing on the use per se. We're basically focusing more so on the structure. The structure is approximately 1.5 feet off the property line on Divine Street side. It would need to meet ordinance 25 feet. So it's not conforming, first of all, because of setbacks. So really that's what we're looking at today, is a nonconformity related to that. We could get into the potential for parking and landscaping and all that being nonconforming potentially, but we're not going there. We're sticking with the structure itself. Another component of this that really folds into the floodplain coordinator or manager is the floodway question about what you can build in a floodway and not build in a floodway. If this structure were completely knocked down, I think you'd be out of luck building anything back. But again, I would want to defer to the floodplain coordinator for his viewpoint on that. From a zoning standpoint, non-conformity that we're talking about today is because of setbacks.
What flood zone is the property in?
I believe it's in a floodway.
Floodway. Did y'all determine that, or exactly, or you just think
in
that?
The floodplain, it's half of it's over Gill Creek, so it's in a floodway. Whether the entire portion or a portion of it is in the floodway, I would leave it to the expertise of a certified floodplain manager.
Thank you. Is the applicant here? Would you like to come to the podium, please, and state your name?
My name is Alan Bullard. I'm here for Moneyline Property. First of all, I want to thank the chair and members of the board for taking that break a minute ago. I had coffee and some water.
Thank you.
So thank you so much. The very first thing, if I may, do is just sort of go over the timeline from our perspective. If we use the city's date of early April 2016 as the 6-month date to apply for a permit, I think even by the information you have been provided in your packet from the city, as we did that, had someone come and try and permit, and they were told, can't issue you a permit, we need additional information. So there was a meeting scheduled in April with the city, past the deadline, so they extended it to May. I'm sorry. Okay, is that better? So we had a May deadline, we had an April meeting, talked with the city and representatives of the city, and they said, well, we need some more information. So we sought about getting that information, what it was going to cost and what we were going to need to do to repair that building. And as they've indicated, prior to the May deadline, we provided the information they requested to the best of our ability and waited for a determination. The next contact we had was, I think, Mr. Cook contacted me and asked if we could meet at the site on sometime in May, and we ended up scheduling it for May 19th. So we're past the May 1st deadline, and we're under the impression we're working with the city to get them the information they need and to get permitted so that we can finish reconstruction of the building. So we meet out at the site, and I'm the only representative there from Moneyline Properties, so any discussions with the owner, of course, is going to have to be with me. And we meet out at the site, and we go through, I think Mr. Weaver was there, and we go through the building. It looks terrible. It was flooded. It was. But we talked about it and discussed it, and said, well, we're probably going to do mold remediation. And we said, yeah, looking at it again, you're right. I'll have a mold remediator come in, give me a scope of work, have it priced by a mold remediation company, and get that to you. Nobody said, don't bother, we're done. I was left with that direction. So we did that. You'll see in your packet there's an email correspondence with Mr. Cook and I where I'm telling him we've had somebody come and scope it, having somebody come out. And in the information that I've handed you, which is missing from the packet from the city, is a June 3rd email that I sent to Mr. Cook saying, it's been scoped, I'll have a price to you by the end of next week, which would have been June 10th. On June 7th, they sent us, we're not going to permit. They didn't allow us to give them the final information. So that's sort of the timeline from our perspective, is we really believed we were working with the city, as they've indicated, they want to get us permitted. They want to get people permitted. They want to get this done. We thought we were working with them to that end. And we're quite frankly surprised by getting a notice 3 days before I said I would have the information to them, I'm not going to permit you. So, what I think we need to, well, I'd like to focus on, of course, is the definition in the ordinance. Non-conforming structure, this is 17-202, shall not be rebuilt, altered, or repaired except in conformity with this article after sustaining damage exceeding 75% of the replacement cost of the structure. And I underlined that, of course, because I think that's important. Because if you look at 17-55, which is the definition of structure, it says, structure means anything constructed or erected, the use of which requires location on the ground or attachment to something having location on the ground. Then it goes on to provide some examples. And our point has been with the city in doing these estimates is that although they would like us to stabilize the bank, that's dirt. That's not a structure. And the cost of that to us is not relevant to the analysis under this ordinance. And that's $23,000 of our estimate, which is in your materials under number 4, mold remediation. I'm sorry, not mold remediation, I'm sorry, bank stabilization, tab 7. So if you look at my summary under tab 1, you have Rosen's appraisal of the replacement cost of the structure. Again, we're talking about the structure, which I think in the city's materials, they agree that Rosen's appraisal is valid. Under item 1, cost to repair without bank stabilization is $58,000. That's 35% of Rosen's estimate of the replacement cost of the structure. It's got to be under 75 for a permit. I don't understand the problem. And the issues that the city has taken with certain of the estimates are what we may call the Goldilocks syndrome. You're allowing the zoning administrator to say, the porridge is too hot, the porridge is too cold, I don't like this estimate, but I'm not going to tell you what it is, and I'm not going to provide you with an estimate. I'm just going to tell you I don't like yours. They've made issue with this HVAC. They provided no evidence that there needs to be any substantial repairs to the HVAC unit. We've provided estimates of what it's going to cost to reconstruct the building. Mold remediation, I think the individuals involved from the city's perspective on mold remediation don't understand it. You may have had some dealings with mold remediation, but non-porous surfaces can be remediated through cleaning. They don't have to be pulled out of the building. They don't have to be destroyed. Ducts, ductwork, countertops, piping, that stuff can be cleaned. That's what the mold remediation company's there to do, is to clean that stuff so it doesn't have to be destroyed. Porous material is a different story, carpeting, things like that. But the initial point is, if you take out the bank stabilization, which is our position, that's remediation to dirt and not the structure, we're at 35.67% of the value of the building, the structure. But even if you include it, you go ahead and include it, which I've done in the second part of my summary there, we're still below 75%. So we're not certain.
I have a quick question for you. So bank remediation would be in lieu of the pilings that would be there to stabilize the building?
No, that's going to be done in addition to. They're both going to be done. What I'm saying is, although it's going to be performed under the ordinance, it's not something that the zoning administrator is to consider when considering whether we meet the 75% threshold.
I was just adding up all the numbers in your presentation, and it came up to $137,949.
Well, in my summary, I've got all the numbers there. I don't know what other numbers you have. That's two separate. In my summary, it's two separate. It's the group of numbers without bank stabilization, and then the same group of numbers including the bank stabilization. They're both totaled. Without bank stabilization, it's $58,903, and with it, it's $82,221. I think you're adding all the numbers.
So I added the bank stabilization into and you're taking it out, basically.
No, I'm saying that in these numbers on my summary, you'll see they're repeated. I think you're adding them twice. You have foundation, Mount Valley, 8,000 under number 1, and then you have foundation.
What section is your summary in?
Number 1. Yes, sir, that's right. It's basically two alternatives. It's one if you don't consider the cost of the bank stabilization, and one if you do. In either case, we come in under 75%. In either case, we come in under 50%. In one case, it's $58,900 if you don't consider the bank stabilization, which is our contention you should not. And even if you do, it's $82,000, which is still below the 75% threshold. Again, the staff has indicated some concerns with the adequacy of the pricing, and as I mentioned earlier, there's
I
been
assume
no...
you're repairing the HVAC system and not replacing it.
I'm sorry?
I'm assuming that that number is for repairing the air conditioning unit?
That's for repairing the building and whatever's necessary, yes, sir. Again, our point, and again, I'm sorry, sometimes I belabor things and maybe mention them over and over and don't mean to, but the zoning administrator has called into question the adequacy of some of our pricing, but has provided no alternative. The only information in this packet and before the board are the estimates that we provided, and there's been no real, there's been no evidence there's anything wrong with them, that they're not commercially reasonable estimates. There's been no counter to them from any competent source to say, well, that's, Rainbow's estimate for remediation is not reasonable.
Can we
EOS's bank stabilization is not reasonable. Yes, sir.
I want to talk about another issue, which I think is even more fundamental, and that's the 6-month rule.
Yes, sir.
Mr. Cook's a nice man. I don't think he has the power to waive the ordinance, and I don't think you had a permit at 6 months. You had the money line was in 15 December, they get the code enforcement, so they know start in December that they need to do something. They cannot just keep drifting along. Then it's in March, then they get another thing, and finally the money line decides, well, maybe I need to do something. So on 29 March, they call and ask, what can I do to get a permit? So we have we don't even have an application for a permit. All we have is a question about how do I apply?
Well, I think actually that we had somebody actually come to Columbia and ask for a permit. Then there was communication. What do
you mean you think you had somebody?
I'm sorry. I don't know the individual's name who came.
Right.
But my understanding from talking with my client is that a contractor was sent to the city to obtain a permit and was told, I cannot give you one. And then there was the email and telephonic conversations between the owner, Mr. Derbyshire, and the city.
What was the problem with getting the permit? The problem was, had you exceeded the 75% threshold, right?
I think the problem was they requested additional information, and I don't know what the problem was.
We don't know about a contractor goes, who's not here today, goes to the permit window. One of the things they want to know there, do you comply with zoning? Right? Zoning rules say, if you have in excess of 75%, you can't rebuild. So I cannot give you a permit unless zoning says you're entitled to a permit. Okay?
Right.
Would it be fair to say, okay, at that point, somebody should find out what to do?
I think the email correspondence or
yes, but my point is,
you need to know what to do.
There was no permit, correct?
There has not been a permit issued.
There's no permit, all right? And your view is that Mr. Cook has some free-floating power to waive the 6-month rule.
I think he has the power to extend it, and he did, and we worked with him.
He had the power what?
He's extended the deadline.
He has the power, despite the city council says 6 months, he can extend it?
Well, it says provided that any permitted reconstruction. No permitted reconstruction had been, no permit had been issued, so they can't begin reconstruction in 6 months.
Without a permit, you couldn't have permitted, right. So within 6 months, we have not started, correct?
They had not, yeah. There's no question that within 6 months of the flood, if we use that number, I think that's a valid date.
Fine. So unless Mr. Cook has the power to grant an extension, you have not satisfied with the 6-month rule?
Well, we were prevented from it.
How were you prevented?
Because we made application and were denied.
I'll go back again. The denial is is a precondition showing the 75% rule is not a bar.
I think the city's a
So
stop.
no, think about it. Could they just give you a permit? Your idea is they should give you a permit and let you start stuff and then talk about 75%?
No, sir, I'm suggesting that when the permit was denied, there was communication with the representative of the city who said, we'll give you additional time, here's the information I need.
That's what I'm coming to. And I see the email correspondence with Mr. Cook. But the question is, can Mr. Cook grant an extension?
I think so, and I think they're stopped from arguing to the contrary at this point.
You're going to stop the government if a clerk says something?
Is he a clerk? If he's
Is
just a
it-
clerk,
wow.
why are we here?
Zoning administrators there's a US South Carolina Supreme Court case saying you don't get a stopple when the zoning administrator tells you stuff. Anyway, that's the point that bothers me, quite frankly, is I don't think the 6-month rule has been satisfied, and I don't think he can waive it.
Well, I understand.
Thank you.
And as to the issue regarding insurance estimates, again, there's no showing that an insurance estimate is any more valid than several contractors who work in this area's estimates. I mean, again, what's a better estimate of what it's going to cost to do this work than someone who is willing, obligating themselves, I will do this work for this amount of money? Insurance company give you just a different cost estimate. There's none before you, so we don't know what that would be, but what makes it more valid and somehow more binding than the local contractors who are willing to do this work for the money, for the amount they've said they're going to do it for? Insurance companies, they're national insurance companies, they plug numbers into their software that has its own particular logic that may not be geared to the cost of doing things in Columbia, South Carolina. So I don't know how that supposed failure is somehow to be held against Moneyline Properties. We provided the estimates, the relevant information, and I don't understand the problem there. And I just think the reasoning behind the city's denial of a permit, which they have not indicated the 6-month issue, is just arbitrary and capricious. We do not like your estimates. We do not have another estimate to show you that yours is invalid. We just feel that it is. And we've presented no evidence to the board to that effect. We've presented no evidence to Moneyline Properties to that effect. We just don't like it. Any questions?
What, did y'all have the property surveyed or have anybody do a
Yes,
flood
we have.
elevation certificate?
Yes, we have that.
Was that not provided in this
We have
package?
it. We had it at the meeting in April. I believe it was provided. If not, I've got copies at the office.
Did you have a structural engineer look at the house to determine whether or not it was sound condition, a structural engineer?
Yes,
Look at
we've
the
been
house?
working with Burke Engineering.
Did they have a report? Is there a report on that?
I'm sorry. I don't know that he issued a report. I don't think he's issued any kind of report, but he worked with the people doing the foundation repair and the bank stabilization. He was there with them and talking with them over what they were planning to do. And that was the other thing I meant to mention. The staff comments regarding lack of detail with certain information. Let me see if I can. No structural details were provided. Again, taking issue.
I just see an email from Mount Valley just says it might be $8,000 based on our conversation.
Well, they came out to the site and looked at it. I mean, that's their estimate. We said, we need an estimate, we got to give to the city, and that's what they gave us. Is it'll take
But
us
they said they
$8,000.
haven't seen a restoration plan, and yet they gave an estimate based on what they think would be an estimate. I mean, it seems like the proper way to do it would have been to have a structural engineer determine what needed to be done and then have that him go out and have the pricing on that and then have him approve that as being, because the main thing, you know, the city's also charged with the safety of that building when it is, as they pointed out, hanging over Hills Creek.
Right.
And frankly, if you look at this right here, that's pretty, I mean, you know, that's not exactly, you know, minor damage.
No, it's not minor damage, I agree, but the structural engineer was at the meeting in April, and he indicated that he had been out there with those people, the people that were planning to do this work, and had gone over it with them. So he was satisfied that they knew what needed to be done and what was going to be done. If they had requested that, obviously we would have provided it. That's the first time I've ever heard that, was yesterday when we received this, that they needed this information. Nobody ever told us. I mean, we were happy to provide whatever they wanted.
I mean, I don't know that you can get a good price for restoration and unless you can get it signed off on that it's going to be a safe building afterwards. I mean, I don't see how you do that.
Well, I think it's going to be a safe building. I think these estimates are going to bear that out. They do the work. We have an engineer that's working with these people, Jesse Burke, Burke Engineering.
Yet I don't see any report from him in this package.
Well, there is no report from him. I grant you that, but again, he was at the meeting in April. He's always been identified as the engineer that's working with everybody.
I don't have any more questions. Are there any other questions? Is there anyone else here to speak in favor or against this? Please note that this is only about the appeal to the zoning administrators. It's not about the business or anything else like that. It's just strictly about the appeal.
Mr. Chairman, if I might, do have the City of Columbia building official here today. If there's any specific questions about the estimate or the repairs potentially, you know, he would have the expertise to speak on that more so than I would, and he's here to answer any questions.
Great. Let's see. Would you like to approach?
Thank you. My name is Eric Miarka. I'm the director of the Gills Creek Watershed Association, and I just wanted to bring up a couple quick points. During the October flood, this building was almost entirely underwater, and not just with standing water. We had directional, quick-moving water, the most destructive water. I think that only the top bit of the sign was what was showing out of this, above the water. So, you know, from my perspective, this is an incredibly bad idea to rebuild this structure where it is. I don't see how you can do stream bank stabilization without moving that building, and I don't see how you could do stream bank stabilization without that counting towards the cost of repair of this building, because unless you fix that stream bank, you're not going to be able to fix the foundation. To me, the stream bank is the foundation for this structure. Also, I don't see an AC unit anymore. I think that got washed away in the flood, so I'm not sure how exactly you can fix the HVAC for $1,000 when you don't even have a compressor anymore. I know that when I had to fix my AC unit after the flood and the ductwork in a 3-bedroom house, it cost $8,000. So I have some serious doubts about their cost estimates for repairs. But I think most importantly, this property is floodway. And with the preliminary FEMA flood maps that are coming out any day now, they're going to go from preliminary to official flood maps. The floodway is actually increasing in size in this area. It's going to go all the way across Croson Road. So this structure is going to be right in the middle of future flood events, which are going to happen again. Regardless of how infrequent we may think these big floods are, they're becoming more and more frequent. We had a 5-inch rainstorm just last week. These things are going to become a lot more common, and I guarantee you we're going to see this property flood again, certainly in our lifetimes. I understand that this could be a financial hardship for the property owner, but the last thing I'll mention is that there are federal resources available for structures such as this one in floodplains. FEMA offers the Hazard Mitigation Grant Program, which the City of Columbia is pursuing right now to do a number of what they call floodplain buyouts. I think this structure and the subway
Thank you very
are
much.
on the top of that list. Yeah.
But that's valid points, and I think it does speak, you know, to, I guess the concern of mine is, and that is I don't feel like the estimates have a lot of weight behind them because there's not a lot of validity behind them.
Thank you.
Anyone, is the building inspector here?
Sure. Mr. Jerry Thompson is the building official, and he can answer any specific questions, but I did consult with him on the various cost estimates. We also, he was present when we did a site visit with the attorney, and he can answer any specific questions, again, with his expertise related to building costs.
I had specific questions. Do you have the contractor's form on this?
I do.
41716. I just, in particularly, I assume that you've been to the building and you've physically inspected it and seen this report. So did you speak with Glenn Weaver? Or
I did.
You did?
Yes, sir.
Yeah, so I guess just give me your impression of this estimate.
I'm a licensed builder myself, and I have been with the city 29 years. I've did assessments, and I've did floods up and down the coast. I know Glenn, but I looked at the estimate, and I even said to Glenn, come on now. Let's discuss this rationally as builders. Ideally, if you took this estimate to any contractor, it's no way the materials. I couldn't buy the materials as cheap, much less put them in. If you really wanted to get down to the nuts and bolts, if you went to the building value data sheet that we use for the City of Columbia, take this building, because it's got to be gutted out. The mold, as Mr. Bullard had said, is bad. This mold is in the ceiling. It's not low anymore. It's been there for approximately going on a year in this hot weather. So once you gut the building out, if you went to a building value plan and it states that it costs $129, just cut that in half. You add that together with your total square footage of 1,400 square feet, you've already got your 75. But what a lot of people aren't considering, it's in a floodway, no doubt. Kmart was in a floodway. Their building's wrapped. If you exceed 50% of the value of the building by zoning, far as floodplain, then you have to wrap it or raise it. That's another $100,000 ballpark. So that figure would put the 75 out of proportion. That needs to be brought up as well.
That's a very interesting point, because that was an issue that a lot of people dealt with, was the 50% value, which is not the replacement cost, and it's not 75. So where would that have come into play in this scenario? It seems like that would have been kind of, hey guys, you got to come back with a new estimate, and you got to have this thing conform to everything that all the new codes and regulations.
It was discussed in the I think the April or the May meeting, or initial meeting that we had, the front meeting. It was brought up at that point that we need to consider that even if we get past the 75, we're over the 50, no doubt about it. And so
Which
we
means
gotta
that
do
you
something
got
to
to, which means you can't do this if you're over the 50, because you got to come back with all new electrical, all new HVAC, all new code requirements, including elevation.
lift it or wrap it.
So you really should have been looking at an estimate based on that, had you gone through that process first, I guess.
That's a lot of variables. Yeah, that building's in pretty bad shape originally.
Okay. Anybody else have questions? Would the applicant like to redress anything? Please come up forward.
Mike Montgomery, I'm attorney here in Columbia, represent the owner of Moneyline Properties. I want to point out a couple of things to the board here. First, this is an administrative appeal, and that means we need to be looking at the record that has been presented by the zoning administrator. And so considering additional evidence or bringing in new testimony is...
I'd just like to say that the zoning administrator brought into his testimony his questions about this, the pricing and the contractor, and so that's why I wanted to go into that more. It was specifically because if that's part of his testimony.
I also want to step in here. As my understanding is the testimony of the building official was that he went and looked at it and has talked to the administrative official as he made his decision. Is that correct?
That's
So I don't
correct.
think we're outside the record here at all. I mean, to expect everything to be down in writing and a transcript of everything and documents is a little steep. I think it was, in effect, part of the decision-making process and counts relevant. It's not ex post facto at all.
And I would concur with you. I don't expect it to be all in transcript, but I do think that the applicant has a right to have fair notice of what the record is and what's being carried forward. The whole purpose we have of having a zoning ordinance is so that citizens can have consistency and predictability in their interactions with government. In this particular instance, what we have is a situation where, I would point out to you, the ordinance nor the regulations contain no guidelines as to what type of estimates we're to have, what is the efficacy of those estimates, who are they supposed to be approved by. There are a number of issues there. So, and the first thing we have to deal with is what right do the citizens have to have an expectation that I present an estimate and that there ought to be, if there is a criticism of that estimate, then there ought to be some ability to move through it. I think what you heard in this instance in the characterization of the timeline is that there are ongoing discussions between the the zoning administrator and the applicant. And the zoning administrator asked for mold remediation information. The applicant advises the zoning administrator that we are obtaining that. And then during the time frame that they're waiting for that information, the zoning administrator makes a unilateral decision not to approve the zoning permit. And Mr. Hubbard, I have to say I tend to agree with you with regard to a question of does the zoning administrator have an ability to waive a timeline in the ordinance. Although I would suggest to you that considering the evidence in the record that because of the time load and other issue on staff they were not able to get to it, I would suggest to you that there is an issue of waiver there that needs to be considered and ought to be equitably considered, particularly in light of the circumstances that everyone in the city has had to deal with after the October flooding event. Here, from a look at the record, what do we have? We have the situation where an applicant has been asked for information. They have provided the information. The objections to that information have been subjective, and they have been essentially raised after the fact without the opportunity for the applicant to continue to address those questions. And the only evidence in the record from someone who is agreed to perform the work is a price that the work can be performed for. And we can all, in hindsight, say, well, I would do X, I would do Y, or I might need to do Z. But the record in the case only reflects that there are firm commitments from contractors who have licenses to perform the work that they believe needs to be done.
I would not say that this is a firm commitment. This is not any obligation. The contractor has absolutely no obligation to perform this work for the money he has down here. He has none. There's no guarantee. There's no contract. There's nothing in this form that says that he has to do the work for this amount.
Well, and I, Mr. Sally, that is not my understanding and is not what has been represented to my client. I understand from looking at the estimate form you can reach that conclusion. But
I would also like to point out that he took demolition, which was $400, out, and it says to be performed by Rainbow International. So his cost for the demolition was $400. Rainbow International's cost is $18,500. So I think that kind of gives you an idea of this guy's idea of what the costs actually, were as opposed to what he's actually proposing.
Well, and obviously, and my my purpose is not to argue with members of the board, but I would also point out that obviously the remediation work is a little bit different than just pure demolition.
Well, if you look at the Rainbow's bid, it details what they're doing. It demo in the ceiling, demo in the sheetrock, and you know, but they're doing it properly. That's the difference.
The other issues that I think are relevant here as we go forward is that it's clear that the bank stabilization is not part of the structure. While it is a cost that may be incurred based on the express language in the ordinance, it should not be included in the costs that are considered as part of the 50 or 75%. And just touching back on the 6 months again, I mean, I think the most critical issue here is there's a two-part process we have here. The first part is that the applicant has to come in and ask for, request a building permit. The ordinance says they have to be issued one. If it is essentially impossible for the zoning administrators to get their approval or get the information that they want, and again, I'd remind you that the ordinance does not say what information or what type of information or what is the applicable standard for the estimates and the information that need to be presented. So you get into very much a question of what I would characterize as both negotiation and a question of what I would characterize as judgment. And so in looking at that, it seems to me that there ought to be two choices that the board looks at today. The first is that they should overturn the building administrator's position and look at the evidence in the record and move forward with that. Or the second is you say, you know, this thing isn't right the way this thing has gone down. We want to work with our citizens better, and it needs to be remanded for reevaluation by the zoning administrator, and to afford the applicant an opportunity to both understand, and maybe the city to have an opportunity to understand what the applicable rules and regulations ought to be in dealing with these estimates in this situation, and to complete the process that in this case was aborted before it was finished with regard particularly to the mold remediation estimates. I thank you for your time. I appreciate your consideration.
Thank you. I just have one final question of the applicant. If you don't mind coming back to this podium one more time, but I just was trying to figure out what took so long to come back to the city and request a permit?
Initially, you mean? In March? Moneyline Properties had several properties affected by the flood, and they were just going through them serially. And this is the one they got to, I guess, last. And based on the work they had done on the prior properties, they just didn't expect any problem getting permitted and repairing them. So it just turned out that this one ran into a snag. But that's why they waited. They just had other ones that were affected throughout the state.
Gotcha. Thank you. Do we have anyone else to speak? I'd like to move then to board discussion. Is there any discussion from the board on this?
Questioning whether somebody can do something for a number, I'm just taking the position that they're going to put it on their letterhead, that they're going to honor it. I mean, we can't suppose that somebody is not going to have the integrity to honor it. But I agree with you, there's no contractual obligation. And had that same question. Why wait? Well, I think the applicant answered that. So, I don't know, we spent a lot of time talking about the numbers, but to me, if somebody's gonna put something on their letterhead, then I've got the idea that they're gonna honor it. Why would they do that? Unless, you know, and I just don't think that somebody's gonna go out there and say, hey, I got a problem, cook some numbers up for me so I can get it through zoning. Not saying that somebody couldn't do that, but I know, some of these contractors, just from my experience in business, and they might not be the ones that I would go to initially, but I don't have any reason to question their integrity. Anyway.
I still come back to the 6 months rule. For whatever reason, the client waited until less than a month till the 6 months run to go to try to find out what the rules might be for the permit. And even though I think it was very nice of Brian to say, we're busy, we'll extend it, he doesn't have the power to do it. I don't, that to me is jolting in a way. Again, I can understand it's always nice to have the people cut you a little slack because it's hard to meet the rules. But, you know, the idea of nonconformities is we want to get rid of them. We don't like them. The city makes it, in the ordinance very clearly says the intent is that they go away. And now the idea that he went beyond what he was empowered to do, and now we have to go by what standard do we judge his behavior beyond when he's doing what he's supposed to do? And how many other kinds of things, if the zoning administrator can sort of create a bubble, an extension, whatever, what other kinds of things can the zoning administrator do? And none of these do we have any standards, since we don't have anything authorizing such extensions on the rules. And I think it was, you know, one of those things, again, Brian is nice to deal with. I've had to deal with him this year, and Andrew, and they're really good people to deal with, and they care about the public. But there are limits to what a zoning administrator can do. And there's nothing in there authorizing him to grant an extension there. That to me is the biggest problem. I think the numbers, I totally agree with questioning, going to whether these numbers make any sense at all. And, we could bandy about who's got the burden one way or the other. But again, from my point of view, we shouldn't even have to worry about that. They waited over 5 months on a 6-month time ticker. Now, whatever you want to say, the time ticker is written in the ordinance. The idea is, read the ordinance if you've got a building that needs to be repaired. So I'm go ahead and make a motion to uphold the administrator and deny the appeal. First, for the argument I just gave there, the failure to comply with the 6 months rule. And secondly, because there are so many reasons to question the numbers here that it's one of those things that I go to what the comments of the building inspector official said. There are lots of ways of looking at what it's going to take to do this right. We have safety problems with that thing if there's another flood. We have safety problems with workers if the mold is not remediated, with customers coming in if it's not remediated. So I tend to come down even on the evaluation issue on the side of the administrator, the zoning administrator. But again, I don't think he could have waived the 6 month rule anyway.
So we have a motion. Is there any further discussion?
We have a second.
I'll second it.
We have a motion and a second. All in favor say aye.
Aye.
Aye. All opposed? Motion carries.
Okay, takes us to the next case, item number 6, 16-036, variance 507 South Edisto, tax map 112120806, a variance to the setback requirements to construct a detached garage, and the applicant is here. Can I answer any questions?
Good afternoon. I am John Swords, and I own 507 South Edisto. Bought it about 5 years ago and started on a renovation project that has now been completed on the inside. I've moved to the outside. This has become more of a project for me and a hobby than an investment, but it is what it is. I have a 67-year-old retired fixed income tenant who used to be my secretary. And so I have an investment in my tenant. There have been some issues in the neighborhood with cars and vandalism and other matters. And in order to address that, I'm trying to construct a garage. The house sits 12 feet from the property line. If I could construct the garage on the driveway next to the house, I would. I cannot. It is physically not possible. Plus, you would have to waive the setback completely, and it's just not possible. So we're trying to put it right at the backyard. I signed a contract for this project on June 29th. My contractor is licensed, tried to pull a permit on the 30th. We learned of the setback issue. We're trying to build a garage 2 feet from the property line. I need 3 feet under the variant, under the setback rules. I need no more than 2 feet, and honestly, probably will build a garage 2.5 feet, so I probably only need 6 inches. But I've asked for 1 foot in variance to give me some latitude. The renderings that I produced show the garage 2 feet from the rear of the structure. That's incorrect. I now know it must be 5 feet from the rear of the structure. So let me make sure I say to you that while the staff has conditioned this upon the compliance with all applicable zoning and building codes, I will comply with that no matter what. We will slide the garage 5 feet from the rear curtain wall of the house. When completed, this garage is to be 14 feet by 26 feet. It's therefore 4 feet longer and 2 feet wider than a standard garage. That's so I can tear down the dilapidated shed that's in the backyard and provide the storage inside the garage. The 2 feet additional width is allowing me to put trusses and an alley down the center of the roof of the garage for storage. The attic space in the house provides storage, but it's quite inhospitable based on ceiling heights and otherwise. I have the approval of the next door neighbors, Julie and Mike McCauley. I spoke with them 5 days before I filed this application, provided them a copy of the application and everything related to it. That was on July 8th. I also spoke to Michael Miller at the Rosewood Community Council on July 12th, the day before I filed my application. I have an email confirming that there are no issues with the Rosewood Community Council otherwise.
Mr. Swords, you've pretty much answered these, but can we just run down the criteria one by one on the variance, just make sure we've got those in the record right? Variance, the first criteria is that extraordinary and exceptional conditions pertain to the subject property. And you've indicated the 12-foot wide driveway and that the garage, obviously you can't enter the garage if it's directly behind the house, so it has to be offset, and you can't build it, obviously, in the driveway. Was there anything else you wanted to add to that?
I don't remember, Chuck, I don't remember all those criteria off the top of my head, but I do.
I'm gonna go through them for you. And so the second criteria would be conditions noted above that do not generally apply to other properties in the area.
there are, some of the houses are not that close on the property line, and some of the houses do have garage structures because of the size. Also, the topography on this house, there are some pictures, you'll see that the driveway is almost 5 feet below the finished floor elevation, so I have to move it to the rear of the property, to the rear of the structure. In the sideline, across the street, the lots are much bigger, and so if I understand number 2 and the special conditions correctly, I think my house and the ones that are similarly situated, have this special condition.
Right, I would agree. And then the third criteria, because of the conditions noted above, the requirements of the zoning ordinance effectively prohibit or unreasonably restrict the use of the property.
If I abide by the 3-foot setback, I can't build a garage. You can't turn into it.
Right. And then the fourth is that approval of the variance would not be of substantial detriment to adjacent property or to the public good, and the character of the district would not be harmed.
Quite the contrary, I think the garage will enhance the neighborhood by getting the car off the driveway. The neighbors do not object to it because this house sits substantially above theirs, and by construction of the garage, they actually gain privacy in their backyard that they don't currently have. There are no windows in that side of the garage, obviously. Code would prohibit that as well. But.
And also, there is the variance the minimum necessary that you're requesting?
1 foot is the minimum necessary, although I may not use that foot. I may only use 6 inches of
right.
it.
So you're going to be trying to comply with that. And then the final is the proposal in harmony with the purpose and intent of the zoning ordinance. And it would not be injurious to the neighborhood or otherwise detrimental to the public welfare.
Yeah, I don't know how to answer the purpose and intent of the zoning ordinance, but I think it's in harmony with the neighborhood, and I think it will not be injurious to the neighborhood in any way. I think that's why the neighbors are saying, right, we don't have a problem. I'm not aware of any neighbor expressing a problem. The sign has been in the yard for 30 days, I guess, or however long.
Very good. Any other questions from the board?
No.
Thank you very much. Is there anyone here to speak in favor or in opposition to this request? See none. Any discussion from the board?
I move we grant the requested variance. As the testimony and evidence has shown, the requirements are satisfied in terms of the extraordinary and exceptional conditions not generally applying, the difficulty of prohibiting or unreasonably restricting the use, and it will not be a detriment to the public or the character. It's the minimum necessary, and it's consistent with the zoning ordinance.
I second it.
All in favor? Aye.
Aye.
All opposed? Motion carries.
Next will be item number 7, case 16-037 variance at 1308 Taylor Street, tax map 09014-0602. It's a variance to the screening requirements for utility service area. The applicant is here and can answer any questions.
Hi, my name is Jonathan Carr. I'm an architect. I'm working for Palmetto Health Baptist, and prepared a 10-minute presentation today on this generator. Can we cue to the first slide? Is it okay? Start off with, let's go to the next one, please. There's a need for this generator that the hospital has. This generator provides critical power that serves the ICU and the surgery departments at the hospital. In the event of a power failure, this generator kicks on and provides power to those departments. And a generator such as this, like any other hospital, requires fresh air. So what that means is that the intake for the generator has to have an unobstructed area for fresh air so that the generator can cool and can operate smoothly. On the next slide, okay, this generator is unique in one way. The hospital has invested $85,000 in additional acoustic dampening for the generator. So the generator has a lower decibel rate than other generators. And the volume that the generator has is less than most traffic noise in an urban setting. Next slide, please. The enclosure of the generator, it has less openings, so it looks more visually appealing. Generator's large muffler, which you'll typically see on some other hospital generators, is internal to the box, so it looks more aesthetically pleasing. Next slide, please. The color of the generator matches Palmetto's corporate color. It's a teal color, and this is complementary to the entire block. The hospital has an accent color of this color, green. In an urban setting, this could be nice in that it's a visual cue for the hospital. If someone was in an emergent state, they would know right off the bat, hey, this is my hospital, I'm going here. Next slide, please. This generator is sited as closely as possible to the existing building. It's sited on an old loading dock. This is a former soiled laundry loading dock. This was not previously screened. The loading dock arguably was not very visually appealing beforehand. The generator is providing something that wasn't currently there and is needed for emergency power. We would really like to comply with the city ordinance. However, in its current state, there's a myriad of underground distribution cables and fuel tank pipes for this generator. The picture on the lower right-hand side of this slide shows that there's all kinds of utilities. Our electrical engineer, Herb Bendillo, is with me today. He can speak more to that if you'd like. But putting a brick screen, which requires footings, would be detrimental to the function of this generator. Next slide, please, deliveries. Trucks are entering and exiting through this active loading dock. So while the soiled laundry loading dock is no longer present, the existing loading dock is still there. And with a brick screen, trucks would invariably hit that screen as they try to make that tight radius in an urban setting. Brick is a very soft building material when compared to a truck that has momentum. And as we often see, brick screens will fall down. Next slide, please. This is a site plan of the current location of the generator and the current curb cut. As you can see, the curb cut is fairly wide. Curb cut right now is about 54 feet. What we'd like to do, let's go to the next slide, please. In good faith, we'd like to reduce the curb cut down. Now, trucks are still going to have the same entrance that they had before, same radius they had before, but it will look much better because we will extend the sidewalk, the grass area, and reduce the curb cut so it looks more built into the site. Do you want to talk to any of the underground utilities that are present?
Yeah, if you go back to the slide that showed the elevation of the...
Could you get to the mic? Would you get in front of the mic, please, sir?
Yeah, if you go back to the slide that shows right there, go back. That is actually right in front of that generator. That's access to a big underground fuel tank that actually provides fuel to existing generators that are inside the hospital. So there's a limit and obstruction to what you could build there in the first place. The main issue with building a screen, as he's touched upon, is that louver there and the airflow necessary for the generator to pull in for cooling and combustion, and the problem with not having a clear airflow path is overheating of the generator and possible shutting down of the generator. So a big solid screen wall would be a considerable problem.
Also, in our packet of materials, we have a letter from Cummins. Cummins is a company that manufactures this generator. There's a problem in terms of screening the entire generator. The more screen we provide, the worse it becomes exponentially for that air to enter into the generator. It's not really a lateral ratio. So the more it's blocked, the worse it becomes. Also, if the board would like, I could go through the points 1 through 5 in the application. Would that be of use to y'all? I'd be happy to do that. And I'm not sure that the answers were provided to their fullest extent. We have additional information behind as well. But the first question was, are there extraordinary and exceptional conditions pertaining to the subject property? This hospital cannot screen the generator without actively impacting the generator itself. So that's kind of an extraordinary and exceptional condition. You know, this is a hospital that saves people's that attempts to save people's lives. So this is kind of an exceptional circumstance. The other exceptional circumstance is that as a firm of architects and engineers, we took great pains to site this generator. We looked at all kinds of locations, knowing full well that some other hospitals, like there was a hospital in New York City recently that had their generator in the basement flooded, and the generator failed to work. That was in the big flood we had a few years ago in New York City. So it is imperative that this generator be positioned in a location where it can tie into the distribution system, the electrical distribution system of the hospital. It has the capability for fuel. There's underground fuel tanks, and it has fresh air. So those are 3 fundamental characteristics of locating a generator. Second item, the conditions above do not generally apply to other property in the area. Well, I mean, briefly put, this is a hospital, so that would kind of apply as an exception. 3, because of the conditions noted above, the requirements of the zoning ordinance would effectively prohibit or unreasonably restrict use. Again, as we talked about, the more screen we have, the less air comes into that generator, and that is a problem for the generator to operate. And then 4, the variance would not be of substantial detriment to the adjacent property or the public good. And, I mean, if the generator did not have an enclosure on it, if it wasn't that teal color, I think that appearance would be a concern. But beneath that kind of shiny metal enclosure, which looks almost like an automobile, let's say, there's all kinds of engines, mufflers, electrical distribution equipment, and so this box is actually providing a screen in and of itself. And then is the variance the minimum necessary? If the board were willing to allow, we hope it will, this generator to remain in place and function as intended, then there is no other sort of other variances that would be requested of the board. I mean, this was I think the question is kind of, is this the terminal application, or are there other kind of impact variances that would be caused by this variance? And the answer is no.
Would it be fair to summarize your position that the function of the screening that is the subject of the ordinance provision has been served in terms of noise and appearance by the design of the machine itself?
I think as a professional, I think that's a fair assumption to make.
While also accommodating what the hospital needs for functionality.
Yeah.
Very good. Anyone else here to speak in favor or opposition? Any questions from the board? Is there any discussion on the board? Do I hear a motion?
I move to grant the variance. The evidence supports the need for it, that the conditions of the variance provisions in the ordinance have been satisfied, and the testimony indicates that. And the concerns, again, of the function, I think, are being served as well. So we have a win-win situation.
Is there a second? I'll second that. All in favor? Aye.
Aye.
All opposed? Motion carries.
Thank you all very much.
Next is item number 9, case 16-040 variance at 1011 Bluff Road, tax map 11205-01-111. It's a variance to the parking requirements for columbarium. And after I looked at what a columbarium was in the dictionary, it's a place where you put cremated remains. So the applicant is here and he can explain his request. It's certainly a little unusual. As you can tell by the aerial above your head there, the parcel is a little unique in the fact that it was probably an old railroad spur at one point. But again, the applicant is here and can probably do a little better job explaining this one than I would be able to.
Okay, thank you very much for having me here. We are requesting a variance on the parking that has been suggested by the city.
Please state your name.
2 parking spaces on site.
Can I get you to please state your name?
Oh, I'm sorry, Whit Suber.
Whit Suber.
Probably the biggest thing and most important thing to point out as we do talk about this is there are 47 public parking places within 600 feet of this facility. They get as little use on an hourly or daily basis as any place in central South Carolina. There are 7 days a year where there's a great deal of parking around this area, but there's probably no area anywhere where there is more vacant parking on a continual basis than this. The facility itself requires no parking anywhere. I will happily accept the remedy y'all suggested earlier that all residents who have a car have to have a space because they will not be driving. So again, that is what we're doing is we're asking for a reprieve of the required parking. The space currently serves as a singular privately held RV parking space with RV hookups. The project that is proposed is private. It is not designated or expected to have any gatherings. It is not a site of ceremony or anything of that nature whatsoever. It is simply a resting place for those who wish to be rested near something that is near and dear to their heart, special memories, frustrations, and things of the like. Again, just pointing out that, to my understanding, the hearing is not about the use. I'm happy to talk about the use, but it's about the parking and if indeed there's a need for it. I also do want to address about the parking that is nearby, very nearby, from the slide you're looking at just to your left. Obviously it's a very pedestrian area. As you look there, you pull forward and take a right down National Guard Road. I haven't seen this image, but obviously I didn't take these, Google did, but that's your typical view of what it looks like on that road. That's how often those parking places are filled, which is pretty much never, other than football games. If it turns around, you don't really have to go through this, but feel free, is Berea Road, which is blocked by a Bud Light truck, but it it's got parking on both sides of the road, and I'm willing to guess that behind that bus, there's nobody parked there either. Okay, 3 cars. So of those 47 parking spaces on the day that Google went there, 3 of the 47 were occupied. Let's see. In terms of use, I will say that we absolutely recognize this is a unique idea. It's a very unique piece of property, and to find a use for it is challenging. The university has tried to acquire the property. They cannot acquire the property. They've been prevented by the Budget Control Board because of the expense of the property. It exceeds what a state government institution can purchase for it. So it's been a source of frustration for the university, and I'm a huge Gamecock fan, alumni, and have been a Gamecock fan all my life, and I am incredibly sensitive to the university. I've worked with them in every way I know how throughout this process. It is a fact, and I can show it, that a full 3 minutes after I received the contract back on this property, I was texting Coach Tanner and on the phone with him 8 minutes after that, and that's how long I delayed in contacting the university and letting them know about what these plans are. On that front, I'll just, I apologize for not realizing that we could have brought slides here, but just flipping through it, we have done endless amounts of plans trying to conform. I don't know.
Let me just ask you a quick question, because I just want to make sure I have this clear in my mind as you go. So what I'm looking at on this aerial right
Yes.
here is, it appears that what you got is a fenced-in lot that has a curb cut to Bluff Road.
Correct.
That I'm assuming that's a gate between the 2 white columns. And so it was
Correct.
originally built for somebody's private RV parking space, and they would come in off of Bluff Road and park in there, and it's fenced off, and it has nothing to do with any of the rest of the property around it.
Correct. And it has been in existence far longer than Gamecock Park has. That is for certain. What it is, and I know we've been here for a long time, and I don't want to take up too much time. It's a fascinating story, but what you can see is it's actually a continuation of what we would call the Cockaboose Railroad. This was a property that Ed Robinson had. One thing that is interesting, and I also think that it illustrates my deep, deep desire to make this thing appropriate, work with the obvious neighbor in this situation, is that you can see how the fencing there in that thing has been altered. That was done at the request of the university when they needed the help of the party who owned the property. They needed an easement from them. That easement was granted. At that time, that property was straightened out. Since then, and I don't want to say the university hasn't worked with me in good faith. They've really, we've worked together as best we can. But I think one of the big impediments is they simply covet the property, although they can't get it. That being said, it's a little bit complicated from this slide. We have readjusted the plans from a plan that I was very, very proud of that fit within the straight version of the property, which the university requested, asked for, and signed off on. And that plan encroached upon the variance most furthest to your, the easement most furthest to your left. The university then was not so comfortable with allowing us to work on that, to build on that easement, so we had to redesign the plans that went on what we keep calling the non-shaded area. My only remedy to that is to challenge the university in some sort of legal manner, which I have the greatest desire not to do for a whole host of reasons. But so I'm doing everything I can to comply, work with them in any way possible. And
What they're saying is leave the columbarium within the fee simple part and stay out of the easement.
Well, actually, that's probably more from the city at this point. I know that somebody from the university is going to speak afterwards. And generally, they don't want it at all. I mean, they want to control the property.
Right.
But in order to not have to force and challenge the university, I've had to readapt the plans. By the way, the plans went from 3,100 niches to 1,800 niches based on that adjustment, and that adjustment is, again, something I've been told by legal counsel we could easily challenge the university on and force them to decide what they intended to agree on when they agreed to it. Was it that they wanted it straight or did they want it curved? Again, I'm very, very reluctant to get into any of those disagreements with the university because obviously I'm trying to work with them. I want a happy situation that everybody can be proud of. As far as examples of, although this is not a cemetery, this is a columbarium. It is a wall with names on it. Yes, there are ashes.
I'm sorry, excuse me. I realize the chair would normally do this, but look, we're talking about 3 parking spaces, and whether you need those 3, you've got, or 2 or 3, whatever. There's lots of parking most all the time, right?
Correct.
Will you let us grant you your variance?
I would be happy to let you do that. I am in such great deference to the University of South Carolina. I'd love for them to stand up anyway. I mean, that's how much it means to me that they get an opportunity to talk. I really mean that. But, would you like to?
Would anybody else like to stand up in favor or opposition?
I have more to say if he does a great job.
My comments very brief. My name is Derek Gruner. I'm the university architect and the director of planning and programming for the University of South Carolina. And I come here today with the authority of the university and its highest leadership to properly and respectfully articulate our opinion on this project. The university does not support the development of this land as a columbarium. I recognize that this variance is actually about having 0 on-site parking spaces as opposed to 2. Frankly, I really don't want to see on-site parking on this site either, which leaves me in kind of a weird position here. But it is important for the university to go on record that we don't think the use of this site for a columbarium is an appropriate use for a piece of property so small, surrounded by the university on 3 sides with a fairly unique use. And the project will be subject ultimately to the South Carolina Perpetual Care Board, and they'll have to judge whether a columbarium can truly go here. But again, for the record, I don't want a silence to be misconstrued as support for the project. You have our gratitude. Thank you.
Any questions from the board? Would you like to come back up, sir? Quickly.
Only say if there's a need to. Otherwise, I'll.
No questions.
I did sort of push you there. As I understand, it's the university's position is the requirement of being in the public interest is not satisfied. In your view, is it
and
is satisfied?
I would note for the record that it has nothing to do with the parking whatsoever, which is what the request is.
Well,
about.
one of the requirements for the variance is to the approval of the variance would not be to the substantial detriment to adjacent property or to the public good, and the character of the district would not be harmed. Again, the gentleman for the university was very brief, and I do appreciate that. But if I gathered that the objection that the university is presenting is that number 4 is not satisfied.
Right. And I would propose to you that, I truly do believe that the university's real interest on this thing is control. I think that's pretty obvious. I have a tremendous amount of respect for that. To suggest that if it were to be a detriment to the property, I would point out the House of Peace Cemetery, which has 2 very important components to it. One, it has no parking whatsoever. And 2, it is more formally known in Columbia as the graveyard next to the soccer stadium, that they're so ashamed about being next to a soccer stadium or next to a graveyard that they printed on their T-shirts. It's not going to ruin the atmosphere. It's in fact designed to be a point of pride, loyalty, dedication to the university. I would argue that one of the most unique things about our stadium, as opposed to so many others, is this private land around it that's been able to develop. If there's any signature item to the University of South Carolina stadium, it would be the cockabooses, of which this was once kind of a portion of that property. And I think it's just more of an indication of what kind of the entrepreneurial spirit of around our stadium has produced, which is 521 tailgating condos, 22 cockabooses, plus about another 15 or so that are on the other side of Key Road. and about 5,000 deeded parking spaces. So the idea of privately owned stuff in here is different. It is a memorial. It's designed to inspire and be something for everybody to enjoy. And I think it's worth noting too that not a single Gamecock fan showed up in opposition to it, nor back to the parking issue itself, nor did the National Guard, which is on National Guard Road.
Well,
and
let's
you can see there
let's
in
go
these
through the
spaces.
criteria real quickly so we can kind of move on through this.
Clarify, but people do come to columbariums. Where the ashes, it's where someone's final resting place is. I mean, people do come. I mean, I can't imagine a scenario where somebody puts their loved one's remains and then never goes down there.
Well, indeed, they would, but there's 47 parking spaces. We intend it's a private thing, and the access will be extremely limited. I mean, for a whole host of reasons, vandalism and things of that nature. This is not going to be an open facility on a regular basis by any stretch.
But if you could clarify, I mean, where will those people that go to visit the remains park?
There's 47.
So you have access to park there.
Correct.
You have an easement over that property.
No, these are public parking spaces. There's 47 of them within 600 feet of the thing. We just up and down both Berea Road. Here we are again. Oops. Berea Road and National Guard Road.
It's much like we grant huge variances in 5 Points because there's just no place to park at the end of the day at all.
And to speak to the detriment of the property, I mean, I think
they're relying on on-street parking.
It's worth noting that, to the detriment, of the property and sort of diminishing its value to any degree, it's only 2,000 square feet. In fact, if we work within the non-shaded area, which we keep saying, which I'm only doing to try to be, to not have to challenge the university, it diminishes down to 1,001 square feet. It makes it very, very, very difficult to put parking on it. We have proposed, and it's in the package, a secondary plan, but that even shrinks the thing further. Our request is that we not have to place parking on it. However, in the package, there is a plan that has parking up in front of it. However, I would strongly argue to this board, no one would ever use it. I mean, why would you park in sort of an awkward position when you can park in so many of these more easily accessible and convenient spaces? So,
I agree with the point that people do visit these things, and it's not uncommon to have a service when the ashes are initially interred. I mean, yeah, I'm going to one in a couple of weeks. I mean, it does happen. But I think, 2 or 3 is all that was required. So, I mean, and there seems to be, you schedule it on, surely you don't schedule it during a game.
and that is one of our policy issues. There will not be ceremonies on this site. There will not be funerals and things like that. And that's not at all uncommon at Columbarium.
You mean there's no way for people to go and,
We won't have ceremonies or funerals there. It's not, that's not policy. We've partnered with Shives Funeral Home, Fletcher Monuments, some very, very reputable companies in this business. And like most ceremonies that would take place, basically would take place in a church or a synagogue or something like that nature. And then the interment it's not a family event or anything like that. It'll be taken at that point by the professionals at Shives Funeral Home, placed in there, and that's how it goes.
And the family would be excluded?
It's not the intent to have them. We have some positions in place. I mean, some of the things that we've talked about with Shives Funeral Home, for example, is that if, in fact, a small group wanted to go there, they could even pull the limos up in front and drop the people off, and if we wanted to do that. However, again, the major intent of the columbarium is the resting place of the party that's there. And once
I just
again,
find it surprising people won't want to go, but I think you have plenty of off-street parking, on-street parking.
And one other
Depends
thing
on
that
whether
we
your
did
family
put in
went to
place, and
Clemson or Carolina or not.
Yeah, I actually have those documents here too, but 2 of the parking facilities right there, Carolina Park and Red Zone, we have agreements with them on rental basis. In the event that somebody wanted to have a wake or some kind of event, Those are the two ones that are not in red right there. That's a perfect illustration. Both of those have given us terms, all this kind of stuff, where people, if they wanted to do something, they could do it there. Maybe you could walk across the street or something like that, but that would be on a basis. I'm trying to encourage the university to get involved in that and let them take that over, because that's all going to be done in a fee, and I'd much rather see the university get those funds than private individuals. And we are, and I don't think he would object, I am making every
So we're here to really address the parking variance. So, I think you pretty much said these. Let's just try to go quickly through. Extraordinary exceptional conditions pertain to the subject property. Clearly, it used to be a railroad spur. It was in a parking place for a condo, but I mean for a RV. So its shape and configuration are limited. Is there anything else you want to add to that?
I'm sorry.
Under those criteria, one, extraordinary and special conditions pertain to the subject property?
Yes, it's quite, it's a very, very small, unique, and uniquely placed piece of property, and, it places limitations on us, and I think those limitations are alleviated by the parking that's readily
And those
available.
conditions, number two, those conditions noted above don't generally apply to other properties in the area?
That is true. It's certainly the smallest piece of property there.
And because of the conditions noted above, the requirements of the zoning ordinance effectively prohibit the unreasonably restrict the use of the property based on the size, shape, and approval of the improvements I think you mentioned.
Yes, it would, in my judgment, place an unreasonable restriction on the property.
And the approval of the variance would not be of substantial detriment to adjacent property or to the public good, and the character of the district would not be harmed.
That is my very, very strong opinion, and I think to illustrate that, we have 231 pre-sale commitments on this project, and the interest level is quite high. And I also should note, by the way, since this has become public, we've been contacted by Penn State, Texas A&M, a couple other schools who are interested in the project. It's I'm proud of the idea. I think it's a pretty neat one.
And then is the variance the minimum necessary?
It is the minimum necessary, yes. I would argue that, and particularly considering all the available parking there, there would be no need to push that envelope any further. Once again, we have put forth a concept that would put parking on it, but now we're narrowing down the building envelope. That would go back to one of the first points. It narrows down the building envelope to almost nothing, and I see no need to go to that. So I would answer to you, yes, I do think it's the minimum.
And is your proposal in harmony with the purpose and intent of the zoning ordinance, and will it not be injurious to the neighborhood or otherwise detrimental to the public welfare?
It will not be detrimental to public welfare. It's really not a very disturbing. It doesn't do much. It's just a wall with people's names on it, and I would argue that's it has.
Thank you, sir.
No effect. Thank you.
Any discussion from the board? Do I hear a motion?
I move to grant the request for variance. I think the record shows that the requirements have been satisfied.
Is there a second?
Second.
All in favor say aye. 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 All opposed. Motion carries.
Mr. Chairman, would you like me to start the next case, or I'm going to take a 5-minute? Mr. Chairman. Ms. Sally. We're going to take a brief recess, or do you want me to?
Yes, that'll be fine.
Make a motion to take a brief recess?
We have a motion for a quick recess, please.
Moved.
Second. All in favor? Aye. Motion carries. That's pretty unique.
Huh? Did you just get my text? How you been?
I'm glad it was all the way through, so I was just curious, because I know Jonathan Arts, who deals with them a lot, and he worked with us at the city, and he's just a really good guy. So I know he'll do good, and some of the others. Well, good, I'm glad. Okay.
I gotta find out about this one.
Andrea, 2 more cases, right?
Yeah, they should go, they're kind of in, I think it's the same
Yeah,
address, it's just two different things, they're gonna have to.
That's the one with the Aflac building. Yeah, when I left church, 'cause it's like I go to Bethel. Yeah, and as soon as I left church, I said, you know what I mean? I remember saw the sign. I went and took a look at it. And I was on Facebook, and I saw on Facebook.
Yeah.
I think it'll be something that's good. So it's gonna be.
Yeah, but you're not, is it Ocean, you're not affiliated with Oceana, are you?
Oh, no.
Oh,
My
okay.
church is in Oceana. I go to the old
Oh, okay.
Oceana Baptist.
Oh, okay.
It's Bethel.
Okay.
And I know my neighbor, I know my church was there. It was the Oceana Baptist, because I didn't know across from it was the Oceana Baptist as well.
Yeah.
I mean,
yeah.
I didn't know it was.
No, I found that out because a good friend of mine, when I worked for, at the state, right across here, I worked at Health and Human Services.
Okay,
And I worked with a young guy, well, Eddie's gotta be older now, but anyway, Eddie Singleton. So
3. 3:30? Okay, so can we maybe do it after that? Okay, cool, perfect. Thank you.
How you been?
Okay.
Ugh.
I need some food. I usually go to lunch pretty late.
Of course.
Okay.
About now? Better? Okay.
All right, we'll go to item number 10, which is case 16-041 special exception. It's the north side of Devine Street, 2801, 2813, 2835 Devine Street, tax map 11316, 13, and 12, 11316, 04, 19, 20, and 21. It's a special exception to establish a multifamily use. Multifamily is allowed within the C2 district, which this property is zoned, with a special exception. The application for special exception is to allow the establishment of up to an approximately 95 unit residential construction upon subject properties within a proposed mixed-use development. The applicant is here and can answer any questions that you may have.
The applicant like to come forward?
Okay, well, we saved the best for last, so.
Don't forget to say your name.
I'm Teresa Hodge. I'm here on behalf of Divine Station LLC. And we appreciate your time and how gracious you guys are with your time to sit and listen to these cases. So I'm going to be brief as possible. I know everyone's hungry. We're here today requesting 2 exceptions for this 2801 Divine parcel. The first is a multifamily exception, and the second is shared parking. Just a little brief history about our company, which many of you, I think, already know. We're a local developer, been here for 30 years, and have developed multiple communities in the southeast, several of which are here in Columbia. 42 Magnolia on Forest Drive, Arcadia's Edge in North Trenton, 5,000 Forest on Forest Drive, and then 700 Woodrow, which is only a block away from this property as well. We're also proud and honored to note that all 4 of our Columbia properties have been named for the Best of Columbia, and that just speaks to the caliber of product that we bring to the table. So, on to the exception. Our request is for multifamily exception within the front C2 properties that face Devine Street. And prior to coming up with any ideas related to what we could do with this project, we met with the Devine Street Association, some members of the merchants, as well as some members of the Old Shandon neighborhood. And we've had several meetings to get together to say, you know, what fits best in this neighborhood and what works well with the surrounding areas. And the actual sketches that are part of the application that are attached, those were born out of those meetings. And so we put those together, showing what they could be. And then we had a subsequent meeting with some of those same people and showed them what we came up with based on their recommendations. And I think it's safe to say that they were all very much for it. They said this idea, of course, this is just a sketch, because we don't generally, produce plans without the zoning before we know what we can do. But in general, the idea and the direction here, they were very pleased with, and they said it was a win-win situation. So I think you have copies of the Old Shandon neighborhood letter in support, as well as the Devine Street Association in support. Got it? Okay. And they great. I don't know. Hello? Okay. So anyway, the idea with this community is to create a mixed-use community that promotes walkability, safety, and quality of life. All of these, we think, are inherent on the Devine Street area, and we think this project would certainly.
It goes.
We're good? Y'all can hear me, right? Okay. Anyway, we can go to the specific questions on the application and go through each one if you'd like, or how would you like
I did have just a quick question.
Sure.
I was just looking at the exhibits. That is the office building being converted into apartments? Is that what I'm seeing, or is that staying office and something's going next door? Could you kind of just walk through what this looks like?
Oh, sure. Sure, yeah, you can go to elevation. So the building on the left is the existing office building that serviced Aflac.
Right.
And it's staying. It's currently being renovated now to provide a Class A office
So that'll continue to
building.
be office? Got it.
Correct. and potentially some retail on the ground floor. We don't know that yet. And then to the right, there's a one-story building there now, so that would be demolished.
Right?
And we would propose to put something like what's up there on this sketch, with retail on the lower floor where
Right.
it's appropriate, and then multifamily above it.
Right, got it. So that's the old counting office, that one-story little building goes back in there.
Yeah,
right?
it served Aflac as well.
Right.
I think previous use, they had about 220 employees packed in those two buildings on that site. Oh, what we're showing here? I don't know that that's been fully determined yet, but we're thinking rentals.
And then there's another rendering above that that's a different roof line that's looks like a 4-story apartment or 3 stories over retail again. Is that,
Yes,
where's
so-
that located?
Well, so to the very right where you see that small portion of building, that's the Aflac building that we're keeping as an office.
Mm-hmm.
And so this is directly across the street at the corner
That
of
corner
Maple and
lot?
Divine. Yeah.
Got it,
It's just a parking lot right now, right there, number 1.
got it. So that's actually on the overhead plan, that's shown, it shows that the building says retail on the top of it, but it's actually going to have apartments above that as well.
Yeah, so we're just,
And then there's-
retail would be on the ground floor fronting Divine Street, and then there
Right.
would be multifamily above that.
Got it.
So,
So, you want to just run through those? Let
I
me,
can. Sure.
if I can help you, before you,
Sure.
you got it? Well,
I got it. The first, yes. It's a maximum of 95 units, which is in his summary.
Sorry. Yeah. Well, the data that we have in our materials, these were prepared by staff, are based on all 4 lots. But if the Aflac building and that lot are not being developed residentially, then the amount of land they're going on is different. For me, the density is different per acre. If we take some of the acreage out, it's higher per acre.
Sure, that's fair. And we wanted the ability to make all 4 of those parcels, to have the exception, for any event in the future that may change it.
So the idea, I just want to understand what we might be approving here today, because
Sure.
it's a little unusual, because we're approving 95 units somewhere on the 4 parcels.
That's correct. Because, even a good example is the center parcel that's in between the office and the existing other building that we talked about demolishing. You never know where the new building, as the sketch shows, will lie over that line. So if it were in that middle parcel, if some portion of it were in there, we would need that to have the C2 exception as well.
The difficulty I have here is that it's sort of a potential double counting here of, since we don't know exactly what's going to go where, as to just how dense we're going to be when this is all over.
Well, so the maximum that we could put on any of the pieces, or I guess one single piece, would be 95.
I understand, but the multi-use means that it's going to be combined with retail, restaurant, and office.
That's right.
And so the overall density is the other 3 uses get thrown in, begins to cascade upward.
But as I understand it, the only thing that we're approving is the density of the residential
Right.
units as 95 units. So then the office and the other retail has to meet their parking criteria through a separate, that has nothing to do with that. In other words, the 95 units that we're approving, any other development of the retail and all that has to stand alone on its parking and has to be provided. So the density is going to be controlled by that.
Correct. And retail and office use or restaurant is allowed as it is zoned now. So we were just asking for the exception for the multifamily. We put a cap on that, understanding that would help. And it is just a cap. Obviously, there could be less. We want to design something that's very in keeping with the area, so. Do you want me to continue to go through the items?
Yes, please. Unless you have another question, anybody else? Good?
Okay.
Let's continue on.
So the first addresses impact on traffic, pedestrian safety, and providing parking and loading. With this particular situation, well, pre-existing, you had all office use, approximately 220 employees that were getting there approximately the same time, leaving at the same time, right? So there's some congestion there. With these mixed uses, it at least disperses that, and it randomizes the trips, which we think helps with traffic. Also, we had a traffic engineer look at it, SRS Engineering, just to assess what a possible sketch like this, how it would affect the area, and the peak trips that it generated on the AM hours and PM hours collectively only increased it by 7 trips. And what it did do is it balanced the entries and exits onto the property, so which makes sense. Office, you could have 40 guys arriving at 7:30, and you could have 40 guys leaving from the apartment building at the same time. It's just a complementary use which supports our shared parking exception that we'll talk about later. But we think that the impact on traffic is actually positive. Pedestrian safety is increased with a mixed-use community because you're putting eyes on the streets 24 hours a day. There's people there at night. There's people there during the day. And pedestrians feel safer that way. And it makes Devine Street more walkable, we think. And the parking, as we address it in the next application, would be provided and would be sufficient for the needs of the specific use at its peak times and throughout the day. Number 2 talks about impact on adjoining properties, noise, lights, glare, etc. The adjoining properties include a fire station, other multifamily use with Grand Devine, and then of course the Devine Street merchants across the street, as well as 1 block away is our 700 Woodrow project that is obviously of similar nature, and we've not ever had any complaints from the surrounding neighbors on that. So we don't think that it will adversely impact those things at all. Number 3, the impact on aesthetic character of the area. We have confidence in our ability, and I think our track record shows that we can do something very attractive and complementary to the area. So there should not be any concern with that. As mentioned before, we met with specific people from the neighborhood and the Devine Street Association to talk about what they thought would fit well. We met again and showed them these sketches, and everyone was really on board with these ideas. I would say nothing is out of character of what's already on Devine Street. Number 4, adverse impact on public safety. They should have the opposite of an adverse impact. As mentioned, you have more people there, desirable tenants will be there that will obviously contribute to Devine Street as well, and the safer the area should be. Excuse me. Number 5, concentration or proliferation of the same or similar types of special exception use. We would say there's limited multifamily mix throughout that area there, and we think that this would really complement the existing uses with the shops, the restaurants, the office use, and then also provide a buffer to the single-family housing that's behind it. 6 is consistent with the character and intent of the area. Again, I think that's very similar to number 3 with the aesthetic character. This is not an overlay district. None of these C2 parcels are. It is a part of the 2018 comprehensive plan. It has several points on it, which these all meet with sense of community, land distribution, sustainability, and addressing the issue of sprawl. Number 7 is appropriate and compatible to other uses around it. We definitely think that's true. It provides more living options, and it provides patrons for the local restaurants and retail spots and office. Number 8, and lastly, does it adversely affect public interest? We don't think it does at all. It's supported by the neighborhood again and the DSA. A lot of them claim it will fill an existing gap that lies there now, and it helps to engage Devine Street from across the street. It provides a better pedestrian experience because you aren't walking by empty parking lots and empty buildings. So we've not requested the parcels behind it that are RG2 at all, understanding the sensitivity to the neighborhood, and we didn't intend to request any kind of different zoning for those. So, do you have any
Thank you
questions?
very much.
Uh-huh.
Is anyone else here to speak in favor or in opposition? Hey.
I am the past president. I'm here. President Tracy Wright could not be here today. Our marketing coordinator, Jennifer Suber, is also here. So thank you for your patience in allowing us to address you. Gentlemen, we've met several different times with estates management. They've been gracious enough to reach out to us. We feel already that we have a good relationship with them. They're already here under 700 Woodrow. They are on Divine Street already. They have proven to be good neighbors at the 700 Woodrow property. As I wrote in a letter that you may have sitting with you, I said that we are pro-business on Divine Street. The Divine Street Association is certainly pro-business and wants to see smart growth. We take great pride in our quaint district. We feel like Divine Street is one of the last few remaining quaint and local shopping districts in Columbia. Not only shopping, but we have shops there. We have people living there residentially. We have office people there. We have restaurants there. So we like to say that people come to Divine Street to shop, dine, and live on Divine Street. And that is true. And we've got a lot of ideas and great plans in the future to meet with city officials and state officials to try to do some traffic calming up and down Divine Street. That's definitely already an issue. Something that we need to address because Divine Street is a state road that we have to address with the South Carolina Department of Transportation in conjunction with the city officials. And that's we're already in works to do some of that. The states has agreed that they think that we could do some things better on Divine Street as far as traffic and making it more pedestrian friendly, bicycle friendly, that sort of thing, but that's not why we're here today. The one thing that I wanted to stress to you today on behalf of the Divine Street Association is that we are concerned with this special exception without limitations. We would like to see some sort of limitations in the special exception. We feel 100% confident that estates management has good intentions and that they are proven and that what they do will be a top-notch development. I feel the responsibility as the Divine Street Association officer that we protect future development, that we protect what happens. And I hated to use this analogy, but I was talking to Bob out in the hallway, and I said, Bob, what happens if you're walking to lunch when we leave here and a Mack truck runs over you? And I knock on wood, nobody wants that to happen. But if it were to happen, then what would USC or somebody like that from coming in and saying, well, we want to buy that property up. You've already exception, and we want to put another student housing project on Divine Street. And that's what I feel the responsibility for trying to protect Divine Street. Now, I know that as soon as you say I want to protect or limit a certain type of person from coming and being able to rent your space, all of the red flag antennas go up to fair housing. And are we discriminating against anybody unlawfully? And I've done my research on that. And I feel 100% confident in standing here before you today to address that issue, saying that all the case law that I've read about, including a most recent Court of Appeals case from our very own state, the Spur at Williams-Brice Owners Association versus Sunil Lala, which is cited at 415 South Carolina 72, just was decided on by our Court of Appeals on November the 18th of 2015, and you may or may not be familiar with the issue that they had going over there, but the Spur, I think you all are familiar with the Spur, which is a development over next to the stadium. That was their homeowners association got together and said, all right, we're going to put in our restrictive covenants that you cannot lease to students. And in their language, they were so restrictive that they said, the rental of any unit to any student currently enrolled in a 2 or 4 year college, institute, or university is strictly prohibited. That's in their restrictive covenants. And you think to yourself, how can they do that? That's got to be in violation of something. But the Fair Housing Act, the federal and the South Carolina Fair Housing Authority, only discriminates against certain class people, and I don't want to misstate anything, so let me pull it up and read it for you. I apologize. Against race, religion, familial status, those are protected classes. Color, religion, sex, familial status, or national origin. Student does not fall in that category. Our Court of Appeals distinguished student from any other category that's constitutionally protected or statutorily protected. They upheld the ordinance. They upheld the restrictive covenant, said that you can discriminate against students. And I hate to use that word because discrimination is such a strong word, and nobody thinks that you should discriminate against other people on those bases. But what good is a restrictive covenant? What good is a home community? What good is a business shopping and dining district if you can't keep the nature of that district quaint?
Okay, I understand your point, but I kind of think that it's the difference between student housing and not being able to rent to a student. Those are two different things entirely. And if you have a mix of students and other people, I mean, just like the Shandon neighborhood that surrounds it is a mix of residents that live there and students that rent apartments there. I have a duplex on Duncan Street, and sometimes it's rented to a student, sometimes it's not. But one half right now is rented to 2 school teachers, and the other half is going to be rented to a student. But for us to say that you can't rent that property to a student, period, seems very restrictive to me. I mean, is there a percentage or something? I mean, it just doesn't seem right that you can't, sorry, we can't rent to you, you're in a 4-year program or you're in a law school or whatever, and we can't rent to you, as opposed to, a student housing project designed to attract students and designed to, with 4 bedrooms or however many bedrooms that they can have to share and make it cheaper for them, all that kind of stuff. That's student housing that is different, I think, than, Woodrow Street. I mean, what about the property they have right now? It's not restricted against renting from students, and certainly that's not an issue.
It isn't right now. That was before our time. That was before my time. That was before it became on our radar to try to watch the development, watch future things. For example, your apartment, your house in Shandon that you're referring to, there is an ordinance in the city that says you can't rent to more than 3 unrelated people at one time. Well, that's restrictive, and that prevents some students from living there.
But that's not the same thing as saying you can't have 1 student in your 95 units.
And what we're trying to prevent is turning something on Divine Street into a dormitory, basically.
I agree, but isn't there kind of some middle ground there? I mean,
I'm certainly open to that, sure, listening to any sort of middle ground.
Okay. Brian?
Mr. Chairman, under our ordinance, currently a private student dormitory like we've seen so many of in the city in the last couple of years would not be permitted in the C2 zoning district. So if we're talking specifically about a private dormitory, private student dormitory, 4 people piling in as they do with student dormitories sometimes, you couldn't do that on that particular property because it's all zone C2.
We also have the problem that the owners of condos, in the case you referred to, agreeing voluntarily among themselves to restrict what they can do, is different from the government conditioning the grant of a special exception, and thus sort of using the power of the government to come in and tell people. I think it gets a lot more complicated. I understand we're all sensitive who are living in town to what happens when you get too many students within one area. It creates difficulties for the neighbors. But crafting this, I don't know. I mean, other than percentages, I mean, how do we define a student? I mean, graduate student, undergraduate student, part-time student, correspondence course, e-course. I mean, just the drafting of it would be a nightmare.
I understand, and the devil's in the details.
Marion, do you have any other things? I mean, I want to come back to you, but maybe if we could get the applicant to come back up and address what their concerns may or may not be. I mean, we may be arguing something that's not an issue.
And on that note, and I'll sit down, we're not concerned about what they're doing. We have a very good relationship with them, and we feel like they're going to do a top-notch community. We don't feel like it's going to turn into a student dormitory with them. That's not the issue. That's not why we have the concern. I feel the responsibility for that piece of property, that what happens 5 years down the road if they decide, okay, well, it's time to sell this piece of property, is there some deterrent to keep USC from wanting to come buy it? That's all that we're concerned about. We don't think the Mundies are going to do anything that's disruptive to our district. In fact, we enjoy our relationship with them. So I just want to clear that.
May I ask you a question? I wasn't at your Divine Street Association meeting, so I don't know. How important was it to the positive views you have here that there would be retail or restaurants on the ground floor of not the old Aflac building, but these conceptual two buildings?
At every one of our meetings with the Mondays and with our association members, that was very important. That was one of the top things that we talked about, that yes, we want it to be inviting. In fact, we had talked about widening the sidewalk to make it more pedestrian friendly, more inviting for people to want to walk there and come shop in the ground floor retail or restaurant or whatever they decide to put down there. That was very important, and that was discussed in most every meeting that we had.
I just want to say that because we're having to operate on a great deal of trust here to approve this, because nothing requires a developer to follow conceptual drawings.
Right. And that's a testament to our trust with the Mondays. You know, they've taken the time to meet with us. They've taken the time to go over their sketches with us and their ideas with us. They've asked us for our ideas. I think they went to the surrounding neighborhoods for their ideas. And we are placing a tremendous amount of trust into them following through with what they have said that they're going to do. I think that's the beauty of having a local developer. I think that's the beauty of having a local district in our city, that we pride ourselves and try to attract local business owners. That's one reason we really feel a strong trust with them, because they do live, eat, sleep, and breathe here in our community. They're involved in the community, and I don't think that they're going to try to do something that disrupts it. It's not them. It's just protecting the property for future development should the unforeseen happen. We can't predict the future. We don't know what's going to happen. And I don't want to take up too much more of your time, because I know we're running late in the afternoon, but I do just want to give you an example of something that we just went through with the corner lot at Sims and Divine with Will Gillespie. He was trying to get a special exception for a drive-through window. After many meetings with him and meetings with you all, we finally came to a compromise. And he's going to have a pickup. Y'all allowed for him to have a pickup window, but you can't order on the premises. That satisfied our concerns, because if Will Gillespie decides to sell that piece of property, which is going to be a restaurant, in 5 years, it prevents Taco Bell or McDonald's from coming in, because you don't have a drive-through window, and we didn't want that in our district. It doesn't fit the feel and the nature of our quaint 1.3 miles. That's all we've got, and we want to keep it quaint.
It's very, very quaint.
Thanks.
Thanks. Would the applicant like to come back up to address that issue?
I think that we would just echo a lot of what he said. We are local. There's a reputation on the line there, and the whole purpose of meeting with the neighbors in the Divine Street Association is not to find out what they want and then not do it. Certainly you could do just multifamily. We have it down the street, but we want to do a mixed use that engages the Divine Street area We have another mixed-use project over in West Columbia with a lot of retail and office and units as well.
What about the restriction that you can't rent to any students?
Well, in general, our philosophy is we don't rent to students. We have certain restrictions in our leases. So from a management standpoint, we don't rent to students. And that was a concern at 700 Woodrow originally with several people. And we told them that's not what we do. And there's a testament to it that that's not what's there now.
So you don't have a problem restricting the use of the property?
Not from a lease standpoint. We would just have to check with our legal counsel on if we can put a restriction on the land. It's in our leases with management, but from the land, I don't know. Because I think we could work it out.
Hey, Bob, if you want to speak to that, please come up to the podium. Sorry.
I think what he was going to say is there's the structure of the lease that they have to abide by, which verifies credit, income, and certain thresholds of which you have to meet to be a resident, which those thresholds allow us to gauge the backgrounds of who comes within our communities to better understand whether these people may be students or not. And we did make a stance specifically at 700 Woodrow that we wouldn't accept undergraduate students. And then through these sources, you can begin to vet where they lie in their backgrounds through these leases.
So as a condition of this special exception, you wouldn't have a problem limiting, restricting the rental of any part of 95 units to an undergraduate.
I could just jump in, Mr. Chairman, just for staff's point of view. I think staff would not be so comfortable with that from an enforcement standpoint, as we do not want to get into checking whom as a student, and are you a full-time student, are you a part-time student, are you a graduate student, where do you go to school? That would be an enforcement nightmare and something that I think from a legal perspective and from a zoning perspective, we might not want to.
This is picking up on my point, the difference between private people agreeing to do something and the government becoming involved.
Right.
It takes you off into what's the purpose of government, and you eventually, whenever you do a restriction, you have to get back to what the purposes of government are. And the only thing we could hang it on is a vague idea of general welfare. A number of cases have wrestled with it, and they've not always been very receptive to anti-student restrictions per se. I mean, when you start saying no students, it raises all kinds of difficulties.
It has the restriction already. It already have the restrictions that are in place for all landlords. About the unrelated people, more than 3 unrelated people, I believe it is, living together and that kind of thing. So. I'm totally comfortable with it, but Marion was making the point, and I just wanted to make sure he feels comfortable. I mean, it's in their lease that they don't rent undergraduates. It's only 95 units, so it's not like you can convert it. I mean, the density level on this to make it work for student housing would be like 600 units. It doesn't work financially for somebody to come in and say, I'm going to convert this to a student housing complex. You couldn't get the rent that you can get, as a single family type situation. So it just
talking to the machine, Orrin. There it goes. But yeah, I think the Divine Street corridor is often overlooked in the sense that, I sell it. I sell residential real estate, and I sell that corridor. Because it's so important to a lot of our downtown neighborhoods, but you're gonna price it out. They're not gonna go and build rental units and catch $400 a head. It just doesn't work. And I've got a confidence in the builder and their track record to where I'm comfortable and not. I'm one of the ones, I hate putting all these restrictions on people. But I just think that the Mundys have got too much invested in the community to have a stain against their reputation. And again, I get what we do and how we restrict uses of land, and Mr. Mundy could get hit by a bus, or somebody could go and sell it or do whatever, but I've got a comfort level without, and I respect where Marion's coming from, because I don't have a problem restricting the use, to saying no students, but then I will certainly defer to Pat as I sit here and listen to this. I just don't see how we can. Quinine Hill is a nice downsized community over by Richland Mall. You can't rent them, period. So if somebody passes away and the family holds that property and it goes from 4% to 6%, it hurts. Makes your tax bill almost quadruple, but you cannot rent the property. So anyway, I think I've got a comfort level in letting the Mundys do what they are very good at doing.
Okay, is there any further discussion on the board? Can I entertain a motion, please? In that case, I would like to make a motion that we approve this application based on the testimony and the written application of the applicant. I believe they have proven that they meet the criteria for this special exception. And subject to, I don't believe, were there any subject to restrictions from staff as far as recommendations? No? So I'd like to make that motion that we approve this request.
Second.
All in favor say aye. Aye. All opposed? The motion carries.
Next item is item number 11, 16-042 special exception, north side of Divine Street, 2801, 2813, 2835 Divine Street, 720 and 803 Maple, tax map numbers 11316, 1312, 11316, 0419, 20, 21, and 22, and 11316, 03, and 04. It's a special exception to permit shared parking for mixed-use development. Now, this one is a little different than ones you may have seen before. The concept and the idea is something that you probably haven't seen coming before you at the board at any point, but the idea behind this particular special exception is to permit shared parking for a mixed-use development. 17346 of the zoning ordinance says shared parking is allowed after review, submission of a study by the applicant, reviewed by the city traffic engineer. This property that Andrew has up on the screen, I guess you can't see it from where you are, but it's basically the properties that we just talked about, and encompasses the parking lot kind of behind the old Aflac building, and then also further up the street. You can see the blue outline there on the corner. I guess that's maybe Lee and Maple. What we were looking for and what the applicant has presented is a proposal to take the 95 residential units that we just approved and combine it into a mixed-use development that would include office space, retail, restaurant, potentially hotel rooms, existing setbacks and other landscaping requirements would apply, and the site plan approval, we would cover that more so. But in this case, the idea is the shared parking, if not located on the same parcel as the proposed shared uses, would need to be restricted through a deed restriction, which they can do that without coming back to the Board of Zoning Appeals, or once they hash out where things are going to go, they have the option of a special exception for leased off-site parking if the deed restriction is not what they want to go with. Ideally, they would get the parking they needed on that particular parcel, whether that means combining parcels or moving lot lines around to get the parking that they need. But this proposal as a whole, and I'll kind of point you to the table off-street automobile parking and storage, Divine Station shared parking. It was submitted by the applicant. Maybe we can pull that up, Andrew, if we have it. So what it does is it breaks down the off-street parking requirements for office, which are what our current zoning ordinance requires. Retail is generally what our ordinance requires currently. The residential, they have listed at 1.3 per unit. It's a little different than our ordinance. Our ordinance restricts it a little more based on the square footage of the dwelling unit. Under 500, it's 1.5 per dwelling unit. 501 to 750 square feet, 1.75 per dwelling unit. And over 750, 2 parking spaces per dwelling unit. But the idea behind this mixed-use development is you take the office, the retail, the residential, the restaurant, and you put them in a shared parking formula, which is, you can see on the bottom of the screen if you were to see the screen behind you, but it's in your packet as well. It's table 2 under the Divine Station shared parking. So the uses are broken down by the day of the week and the time of the day or evening or nighttime. And there's a percentage that it hashes out to based on the parking at that particular time. So the City of Columbia traffic engineer has reviewed the model that we're talking about now and agrees with the basic methodology with the model. The traffic engineer did have some questions about the totality of the information that is available at this time relative to the surroundings and the potential for uses. The table is sound in the fact that the parking that would be required for certain uses are laid out, and it would be staff's point of view that any use that would come in the future for this development, we as staff would have to look at this formula, would have to figure out what's already there, and that would be provided by the developer or applicant to aid us in making that determination. But we would have to use the formula that the shared parking formula that the applicant has provided to come up with a determination of, based on the number of parking spaces that we have, does that particular use work. So for example, if you came in and just did all straight restaurant, obviously it wouldn't work because it's a higher use. If you came in and mixed it up with residential at 1.3 and some retail, maybe a restaurant, and that formula based on what the parking calculation ends up being, based on that calculation, it may work, it may not work. So that basically it would be put upon staff working with the developer to make sure that should you be inclined to approve this request, that these numbers do hash out based on this unit count, this parking that would be required in this formula, which basically is the ULI cross park percentages that the applicant has provided. And Teresa probably can do a lot better job explaining that particular part than I have, and I'm sure she'll probably delve into that a little bit. So I'll stop and just let the applicant kind of.
I have a question. If we follow the formula, which requires less for retail than restaurant, as I understand the
correct.
So if someone wants to put a restaurant where retail is, decided that would be a better use for that particular thing, the retail's moved or whatever. If they've maxed out on parking, are we then going to face a variance request or something? I don't. If they max out, then what do you do?
Yeah, potentially at that point, if they max out, they couldn't do the use, so they'd have to come back before the board, either with the adjustment to what was approved today or a variance request to basically trump this request.
So there would be a requirement of some sort if they have maxed out.
Yes, correct.
Thank you.
the applicant like to come forward?
Again, Teresa Hodge on behalf of Divine Station LLC. So, smart development and growth is what we're all striving for. The City of Columbia wants it, and they're doing things that go in that direction, because we all know if you're not growing, you're dying. So parking is one of the largest land uses in our nation per Urban Land Institute, and shared parking helps reduce the amount of land that is needed for that use, thereby providing areas for green space, for more development, and it also helps with environmental things like stormwater runoff and things like that. We have the opportunity here to develop something special that will enhance and uplift this area, as mentioned before, and with the support of the neighbors and the Divine Street Association, we feel like this is a win-win situation. ULI defines the shared parking as the use of a parking space to serve one or more individual land uses without encroachment. So intuitively, we all know that office users use parking during the day, residential's peak use is during the night, and that's reflected in that table that you're looking at. Office is at 100% per this table, which is pretty conservative considering you really don't have an office building that's 100% full most of the time. So that's got some cushion built into that. And then
Let me ask you a quick question.
Sure.
Who prepared this chart?
The table is from ULI, Urban Land Institute, and a noteworthy thing is Greenville actually has shared parking in their municipal code, and the same table, exact same table, yeah. Okay. And it's used nationwide. We have a notebook here of studies with ULI and other areas where where shared parking just makes sense and it's smart development. So I'd be glad to pass that around if you'd like, but that's where the table came from. And as he mentioned, the uses per, like the 3 per 1,000 for office, that's in the code, and the only one that differs is the residential, and I will get to that. Like I said, a lot of municipalities are already using this, and I know even our city, as they're revamping the zoning code, plans to put something in there that would address shared parking, because it is smart development. We have one of the quotes in the book is the most important strategy as it relates to parking is to have a varied mix of uses in the development with attention to those that have opposite peak times. And we feel like what we've presented here as our plan does that very thing. Multifamily office, or opposite, retail and restaurant, most of those peak at night with some use during the day. So as long as you provide a sufficient amount per this table, which is proven nationally, then you would have ample amount of parking, but it's sufficiently used and you're not providing an oversupply. So I think that deals with the validity of the model, especially considering even local municipalities such as Greenville, and they're very forward-thinking with their development, that they've already accepted it and put it into their code. Some of the benefits of shared parking is it provides an efficient use of the land, so you aren't paving entire areas that could be used for green space or development. It increases property values. Parking lots generally do not increase value, but development does. It creates a sense of vibrancy throughout the community because there's constant activity during all periods of the day. It balances traffic use because you don't have a congestion of all the office guys coming at one time and leaving. It's very balanced with, as mentioned, with the traffic study. Quality of life, we think activity at night makes for a safer environment. Even if a worker wanted to stay or come back to work at night. I know here in downtown, I would not come back here at night and work because I would not feel safe. But if there's people that live there and there's restaurants and activity, I certainly would consider that. And again, it reduces the cost of construction and operations, which generally gets pushed through to the end user. So it helps with rental rates, it helps with rental rates for office. And those are some of the benefits of it. We can go into the application like before and go through each line item.
Could you walk us through the table?
Sure.
That actually has the number of units and the parking required with a total of 166 spaces?
Sure. Let me find that. You got that?
It's right under the site plan where it shows the offered parking spaces 172.
Is it the next item? It's one of There it is, 166. We've done so many models, and that's the beauty of the model is that you just put your inputs in there, and it adjusts what your peak is.
So is, I'm assuming that you've got like 30,000 square feet of office space, 5,000 square feet retail, I guess 95 residential units, 4,000 of that square footage. Is that what that little table on the right is saying?
That's exactly right. And if you reference one of the handouts I gave you right before the meeting, it shows kind of existing parking, which is here, this one that says existing parking opportunity. So currently that large green area has 113 spaces, but it's extremely inefficient the way it's designed and striped, too wide of drive aisles, it's not connected. So we've done a study where you can make that more efficient and get 133 spaces there, approximately. And then the lot next to it has 45 with nothing on it, and then the 15 in the back. So there's really like a total of, 100, and I think that was 193 spaces total there now. The second that says optional parking opportunity matches similarly to what our multifamily sketches show, where there would be 24 spaces there because there's a building, and then that's the max number there is 173. So that's kind of your number of available. It's either 173 or it's 193, but certainly when we go for permitting, the city would know what's available there, and they would base it on that.
Yeah, and so I guess the total required then becomes the maximum number of each space for the maximum period of time. In other words, whatever
The max use.
whatever period of time that you have that has the maximum number of requirement parking, that becomes the parking that you're required to have.
That's exactly right. Okay. So, and he inputted up here. The retail is several retail uses have 3 per 1,000. So, we look like if you had a convenience store, it's 3.5, which we don't really plan to do. So if you had soft goods, it's really 3. So that's kind of interchangeable between office and retail as far as required parking. The 95 units is the max that we recommended. Again, that could be lower. And, once we do have an exact use, it gets put into this model. And then the restaurant obviously has a higher use. So if you didn't do the 4,000 restaurant, you did no restaurant up there, the retail jacks up to about 10,000 that you could potentially put on the site with the shared parking. And regarding the 1.3, so obviously multifamily is what we do. It's our bread and butter, and we study our parking in all of our properties, especially here in Columbia because that's directly relevant. But even more so, 700 Woodrow is a block away. And we study at all hours of the time of the day. We did a study, and at the max use on that property is 1.09 per unit. So even what we're requesting here is 20% higher than that. We got 1.5 approved there, and there is always ample amount of parking available. So again, we're just trying to be efficient with what we know will be needed. And we have certainly backup for the studies on our properties to show that. So that's why that for the variance in that versus what's in the code. Is that helpful with the
That makes
model?
a lot of sense.
Okay.
Do we need to go through the criteria kind of just quickly?
Sure. I will be as quick as possible. So the first one is the impact on traffic, pedestrian safety, and parking. As a rule of thumb, a lot of these are what I said earlier. So mixed use, as shown in the traffic study, it shows that the trips will be randomized and will help with the issues of traffic. And again, the peak trips, even with these other uses, have only increased total for 7 for the day. In the AM, I think it actually reduced the amount of AM peak trips, and at night it increased them a little bit. It certainly makes for a better pedestrian experience and safety. If you have more green space or more development versus a huge parking lot that has empty spaces in it. I'll go to the next one, number 2, the impact on adjoining properties. Again, we don't really think there'll be an adverse impact on the adjoining properties because these are all complementary uses. So we would certainly argue that this is good for the area, and the adjoining properties would agree, I think. Number 3, the impact on aesthetic character. we're really talking about parking here. So the buildings certainly attribute to the aesthetic character of the area, and then I think reduced parking, as long as it's efficient, is very good for the area. The adverse impact on public safety, we think that parking lots that are full are better and provide, for well-utilized parking areas versus large empty lots that people don't feel safe in. Number 5, concentration or proliferation of the same or similar types. We would argue that there's not enough of this. And I think, with the new city code that's coming out, it would help promote this type of use, and there will be more of it, and that will be better for everyone, honestly. It's consistent with the character and intent of the area, that we certainly think that it is. And it's providing parking for the uses. We're not even counting the the off-street parking that is on-street, that's already there, that's available for the use of the patrons as well. Appropriate and compatible to other uses around it. We certainly agree that it is. And it would serve our use as well, and not detract from the uses on Divine Street or the adjoining areas. And then finally, does it adversely affect public interest? We would say not at all. It's supported by the neighborhood, it's supported by Divine Street Association, and it clearly provides a better pedestrian experience because you're not walking by parking lots, and it creates a vibrant neighborhood that we can all be proud of. So that goes through all the questions. If you guys, this special exception is necessary for the next step of our design of this property. And we think that this model for sure sets parameters on what we can do, because it's just simply going to be managed by Brian and Andrew as we would submit for permits once actual plans are in place. And we think that there's definitely a level of comfort with that. So if you have any questions, we'll be glad to answer them.
I think that was a great presentation. I think that this very thoughtful plan, very progressive, and certainly it makes a lot of sense in the development of the property and not creating more and more parking lots and things that aren't needed. So I applaud you in your thoughtfulness on that, and understanding that you've got now a plan that gives you some flexibility as to what goes in, but also assures that you'll have adequate on-site parking for that plan. So I don't have any other.
I have some questions. At this beginning, Mr. Cook went through a list of conditions, and I don't know if you were taking notes at that time. I wanted to go.
Is it the same conditions that are listed on your case summary?
Yes.
Yeah, yes.
Do you have any objections to those?
We don't. Regarding the deed restriction, and just talking with our counsel, we would ask that it could be a restriction of record that would allow for a more global parking agreement.
Allow for what?
A global parking agreement versus actually putting a deed restriction on the land.
The overall mixed-use development that could get recorded and be of record that would manage it versus per se. It would just be it'd be a restriction of record versus a deed restriction.
But if you're going to view it as one big parking lot?
Yeah, so it could kind of take the parcels together and put them under a parking agreement and say how this is how the parking's to be shared. It would follow that model and kind of basically say that, and it would be a restriction of record.
Does that work? You don't know.
For the residential portion, less so than the commercial or office portion.
One thing I was wondering about, the lot at 720 Maple is behind the C2 properties. Is a residential classification, is that correct?
Right, and it was used prior for parking for Aflac. It was a deed restriction in place prior to this that was lifted, so it's been used functionally as office parking. So what staff would want to look at, and we can work with the applicant on this, is basically trying to get the parking needed for the residential, on the residential lot, and then the other parking being, the ordinance says deed restricted parking, so it may get into a legal question about, what satisfies that word of deed restriction, but,
We're glad to work through those details.
I guess what I'm going to is that if it's one big parking lot, isn't there a provision about using a residential parcel or residential district for commercial parking, that you need a special exception for that?
so in this case, we're looking at the map, well, I guess you can't really see numbers, but basically the residential zone property back there and there are already used for, or have been used for offices in the past. So there's that question of whether you can continue to use it as such, or does retail kick into another category. But specifically to answer your question, if they tie all the lots together with a shared parking agreement and it's been used as office parking for all these years, it'd be my opinion that it would meet the requirement.
Pardon?
It'd be my opinion that it would meet the requirement, being that it has been used for various office
That would
and
apply-
other uses.
Would that also apply to the lot at Lee and Maple?
I think it would because of the prior use. The applicant may be able to,
Was Lee and Maple posted?
all the properties should have been posted. I didn't go out personally, but all the tax map numbers that were listed would have been posted by the inspector, should have been posted by the inspector.
I'm going to have to recuse myself. Because I was in some meetings, and I know some things that I'm recusing myself, I'm sorry. In meetings with the neighborhood, the Lee and Maple was never mentioned as a part of any of this. And it will surprise people. But I think the best thing for me to do is just recuse myself from the rest of the meeting. Thank you very much.
Okay. Any other questions from the board? Do I hear a motion?
Is there a way to find out if it was in fact posted? I feel like that's...
See Andrew nodding his head. But I don't want to mistake that for his hunger pangs.
The properties were posted. I would have to double check to be 100% certain on Lee and Maple, but I can try to call back to staff, but I'm about 99% positive.
Could we defer it? I'm just asking. I mean, we're here. We're like right at the. Could we defer it? I mean, like I can understand totally what Pat's saying. We,
I know that I'd be willing to defer. I mean, like I said earlier, I always respect, and Old Shannon is certainly one of the neighborhoods where you've got people who are big time invested. And I would think that with something, I got phone calls about this, and I did my normal, if you want to talk, get on the mic, so I don't have to recuse myself. But I think there's been enough public interest in this that if somebody had a problem with the property being posted, my supposition is they would have, somebody would have brought that to either the city's attention or come up today, and I don't have any reason to think it wasn't posted.
The only inspectors, they look at the tax map number, they would have looked at this map, they would have posted the property.
Yeah.
There's always that wild card. But if nothing else, it would have been posted, to alert the neighborhood that something was going on.
I must admit too, because I go to church like one street over, the Old Shandon, and I actually left church and went to it. So yeah, you're right. I think it did get quite enough attention. So
The letter from Derek Riley, I mean, clearly he's seen the agenda and has referred to it in his letter, which shows the lot in the materials and information as well. I mean, it's clearly in every part. There's a close-up of it. It's outlined in blue in each one of the parcels, and I know that in the letter it references that they've looked at it. So I'm comfortable with moving forward with the request.
Yeah, I mean, I guess, Chuck, having looked at that letter, it brings a certain level of comfortability with me, so.
I'd like to make a motion then that we approve this request for a special exception, subject to the conditions outlined by staff in the application. And I would like to also say that staff would have the right to figure out how they would like to work out with the applicant as far as the restrictions are concerned, whether those be recorded restrictions in an agreement that's recorded in the courthouse, or deed restrictions after they've had a chance to seek counsel and look at that further. We have a motion and a second. All in favor, say aye. Aye. All opposed? Motion carries.
Yeah, I'd make a motion to adjourn.
Yes. Second. All in favor? Aye.
Well, I don't know. I want to talk. No, I'm just kidding.
Let me out of here, Percy.